Yes.
Lord, your Lordship, permit me. Mention item number 6.
Of-
With the hearing item.
Hmm.
Do we have prepared our affidavit? We have sent for Lord
Going to
vetting. So, my Lord, if your Lordship accommodate for just for 2 weeks, I will inform the other side. I could not contact him over phone.
Mr. The learned counsel appearing on behalf of the respondent number 4 and 5 submits that he is in the process of filing the affidavit within a period of 2 weeks. Taking into account the above, is the matter again on 28th of August 2020.
Obliged.
My lord, WPC number 1827/23. My lord, it is very urgent and may kindly be listed on 31st of July. My
Which
lord,
one?
my finance has been stopped since January 2023. I am a contractor and construction work is going on in route and also a business. On several days, the case was listed in court number 7, but the item could not be reached, my lord. My lord, may kindly fix it on 31st of July.
No, Mr. Counsel, today court number 7 is not sitting.
Court
When?
number 7. Matter relates to court number 7. sir.
Ali court number 7 ko rako kitne? No.
It was listed yesterday, my lord.
Court number 7 list given to me. Okay. Is there any notice that I should take up court number 7 matters? Yes, tell me.
WPC number 1827/23. My lord, it may kindly be taken on 31st of July.
Why?
My lord, the matter is urgent because my finance has been stopped by bank since January 2023. Due to decrease in my lord, according to me, it is illegal. There is decrease in my civil score, and this and unsolicited issue of credit card by SBI Card and Service Limited. This is disputed in this writ petition, my lord, and already 3 respondents has appeared, and they have already been informed regarding this, my lord. The matter is that is why urgent, my lord.
Okay, we'll have you on 31st.
Of July, my lord. Obliged.
Killing by my lord, killing of a man, my lord, by while elephant. It was
Huh?
listed while elephant. It was not killed. My lord, matter was listed 1905. Written
Killing what?
lordship for compensation, my lord.
Then?
It is admitted. All papers are my lord, already in favor of the petitioner.
So what is the urgency?
Urgency, my lord, petitions there. It was a matter of the year 2001 to 21, my lord.
Oh, you mentioned in the regular bench. Why
Uh,
should I give you?
long date, my
Oh,
lord.
sorry. No,
Oh,
nothing doing.
Made with the Lordship. I beg to mention for a listing of a writ petition, my Lord. It relates to a tax-related dispute. Tax dispute, my Lord.
Hmm.
Any date after 7th of August, my Lord, will be. If the
Why? What is the urgency?
My Lord, what had happened in this case, my Lord, and the income tax authorities of Dibrugarh has raised a demand against me. We have contested it and they passed an order. We are now of this belief that they might enforce that award against them. Now, this award is against that our jurisdictional high court is the violated of our high court's order.
So
So
you have filed a writ petition.
Yes, my Lord. We can because it is violated of.
You filed a writ petition.
Yes, my Lord. We have filed it.
Now, once the writ petition has been filed, what orders did you get? Did you get a stay order?
No, my Lord. It to be listed for motion.
For motion?
Yes, my Lord.
Huh.
For
Oh.
motion, my Lord.
You want to do it today?
Any date on 7th of August, my Lord.
Then mention it before the next.
Please, your Lordship. Lordship, I am praying for a listing of a threat matter, my Lord. This is a writ petition regarding Panchayat no confidence motion. Network order may be passed again against.
You want to do it today?
My Lordship?
You want to do it today?
No, my Lord, tomorrow, my Lord.
Mention it now. Take it up with the registrar. I'm not going to put a burden upon my learned brother when he comes tomorrow. If you want, anybody wants a matter to be done today, I can take it. Otherwise, no. Sorry. Don't mention.
Yes, if your lordship the vaccination hearing item, hearing list item number 108, Lord.
Hmm.
Engaged counsel Mr. D. Nandi is suffering from fever. Lord.
Who?
Engaged counsel Mr. D. Nandi.
So you do it.
Lordship, I
These are all matters, no adjournments. Next.
thank you, Sir Lordship. I beg to mention for listing of a contempt matter 441 of 2020.
Mention it before the regular bench, not this. Whenever the court. Next.
Please, my lord. I beg to make a mention for item number 2 of the daily list. Your lordship may not like to take up this matter.
Okay.
I am for the item number 1, my lord.
Why? Why both are analogous? Huh? So maintainability, if you raise in any matter, would it come, would it be same? Now why both the matters are said to be same? Other same. Oh, why can't I take item number 1? I'm not taking up item number 2. I'll take up item number 1. Yes, next.
My lord, the counsel from item number 1 is from Bombay, my lord. They have told that, my lord, this matter.
You got to stay. We vacate the stay, then whatever happens.
My lord, there is a demand of service tax, my lord, in the both cases, my lord. Therefore, my lord, in this matter, both matters are.
I'm not concerned about the second case. I'm concerned with the first case. Item number 2, not before me. Item number 1.
Accommodate for today, my lord, as my lord, the item.
We'll see when the matter is called. Next.
Of like,
Like to mention a matter for listing for tomorrow.
Why?
The matter is urgent. There is a departmental inquiry which was initiated on the basis of an anonymous complaint. The second round of litigation, the first round of litigation.
Why the departmental inquiry before in bench 4? Why is it in bench 4?
On the earlier occasion, also the matter come up before since then 4 years.
It's a departmental inquiry. That's a departmental inquiry is a matter pertaining to bench 4. No, it's a bench 3 matter. Yes, next.
May I please, I beg to mention for listing tomorrow. I have filed a repetition 21/7. I beg to mention for listing tomorrow.
For what?
For what, your electricity connection. This connection, I am in a resident, this connection till 30 July.
Then?
Thereafter, the authority will disconnect. I am residing since 2014. I have paid entire consideration amount and.
Okay, tomorrow. Next.
Lordship, item number 5, we have filed our affidavit yesterday. Lordship, may hold our records.
2015 matter.
Yes, Lordship, we have filed our affidavit yesterday, Lordship. I kindly hold the records.
Supplementary list, item number 9 from motion.
Are these matters connected? 1, 2, 3, 4 of Justice?
No, Your Honor. That's another matter.
These are the another matter, Lordship. Relating to service sector.
These are service tax.
Item 1, 2, 3, 4 of court number 7, Lordship.
So those I am not taking.
No.
Only this. Then.
My lord, those matters, if the lordship to direct to keep on 21st of September, your. Because the matters are, their connected matters are pending before the tribunal. And that was one of the main grievances that the assistant commissioner.
No, that means there is no urgency. So I won't take up that matter.
Fair enough.
I'll take up only item number 9.
Very good.
Yes, Mr. Kyle, what do you have to say?
In this case, Lordship, I obtain instruction. The concerned officer is on transfer, Lordship. Here, this Lordship may pass interim order. We will file our response, Lord. Because privacy, there is a judgment of reasonable vote against us, Lord. Against that, we file application, went to Supreme Court, Lordship. One IA is pending. In that case, all these cases have been taken. That is why.
Understood, but that matter has been recently settled by the Supreme Court saying that those people who have already got the refunds, who have already been settled out there earlier prior to the coming into effect of the unicorn judgment,
Yes, Lordship.
then those cannot be reopened.
But that is there, Lordship. Lordship may pass interim order, will not take any courtship action against them.
Which are the orders? Just give me a, which order is there? Any of the orders, what is the direction passed?
Page 312, Lordship.
Page 245 onwards, Your Lordship. There are 4 orders which have been passed.
What is the final outcome?
Final outcome, Your Lordship, what he
I
has done
dropped the
is,
demand of education cess of so and so amounting to Iman. Sanction for the July of, I dropped the demand of the interest and penalty. What is this?
245 onwards, there are 4 orders ending up with 3.
No, what is the final outcome of that order? Just for
Final outcome
example,
of
in
that order is
two,
some other matters which are not related, Your Lordship. Can I just take Your Lordship to two pages, Your Lordship?
Mr. Counsel, kindly show me that any of the impugn orders, what is the order passed? The last final conclusion.
Yes,
Is this page 363 is an order?
yes, Your Lordship.
Let's see what is that order passed.
Page 263, Your Lordship.
363?
263.
Yes. This is one order. Now, what is the final outcome of this order?
What he has done, Your Lordship, in some cases, he has dropped the demand. In some cases, he has confirmed the demand and said some other pending dues I will adjust. So on technically, the refund has been sanctioned. The refunds were already sanctioned. And those sanctioned refunds have been adjusted against something else. Can I just show Your Lordship two
Kindly
pages?
come to page 274, the order.
Yes,
What is it? I dropped the demand of education cess amounting to so and so. And secondary education cess of amounting here for the period from so and so in terms with the so and so. I
Yes.
dropped the demand of interest on penalty. So and so is disposed of. Now what remains?
this is only in respect of one. Your Lordship will kindly see page page 299, Your Lordship.
Yes.
6.2. I confirm the demand of education cess amounting to rupees so and so, and of secondary and higher education cess amounting to rupees so and so, in terms of proviso to section 11A1 of the Act as amended. So this is how he confirms the demand.
So this is for,
After having sanctioned all the 4 refund claims in terms of SRD nutrients, he issues the show cause notice. Which show cause notices? have
did
been
you get the money?
I got partial money here.
Okay.
In respect of 2 of the periods, I got the money. In respect of 3 of the periods, I did not get the money. Then in that connection, I just wanted to show 2 pages, Your Lordship. When he sanctioned page 109, volume 1, page 109.
We don't have volume 1, only one volume.
Oh, I'm sorry. Right.
Yes, 109.
For ease of handling.
Yes.
Page 109, where I'm saying, thank you for sanctioning the refund. However, the operative portion of the refund order reads as follows. I hereby sanction refund amount of so and so and order to appropriate the same against their pending dues, thereby refrain from disbursing any amount as refund to them.
What is the date of this communication?
This is 9th of June, Your Lordship.
How do you say so?
I'm sorry, it's not put here. Page 110, Your Lordship.
Huh?
And I've quoted everything. Page 110, next page. 29th of June, 19, where I have extracted the orders of this honorable court Justice Rishikesh Roy's order.
Okay, this was sanctioned in 2019.
Yes, your lordship.
When was the amount sanctioned?
This amount was sanctioned much earlier. Your
When?
Page 21, your lordship. 2nd April.
Page
Page 21 is a small table which I put.
21.
Yes, your lord.
21 is your writ petition.
Yes, your lord. In the writ petition, there is a table.
Okay. When were these amounts sanctioned?
Next para of this, by refund orders dated 2/4/19, 7 June 19, 18 June 19, and 19 July, refund claims were sanctioned by the third respondent.
And unicorn came in 2020.
Yes, sir.
Yes,
Yes. So the refund claims were
So we are
sanctioned.
concerned with these 5,
We are concerned with these five,
nothing else.
nothing else.
And by impugn orders,
He-
by the impugn order, these amounts have been,
These amounts, some amount has been sanctioned to me. That's exactly what I was showing to my lord.
no, if I stay the entire thing gets stayed.
No, stay is no consequence, your lordship. He has to disburse the amounts to me. Can I just in that connection showing only 2 pages?
Hmm.
As to how I got the money, page 110, your lordship, where I'm telling him that you are good enough to sanction, but appropriate against pending dues which have been stayed by this honorable court. So please don't do that.
Where
Page 110 is my letter of 29th of June. Your Lordship.
we are thankful that you for sanctioning an amount of
Yes.
5 crore.
Where I show to him,
The refund for 3 months, the refund has already
And-
been rightly sanctioned by the government. The banking. Able to get the refund. That wasn't so. It will 100%. It will 100%.
and at page 112, your lordship, I quote the division bench order by Justice Rishikesh Roy and Justice Buchan, where I happen to appear, your lordship, staying the other demands. Then I requested him at page 116, kindly disburse, failing which I will have no option but to move the High Court. Immediately, the commissioner writes to me at page 139, please hold your hand, I'm releasing the money.
Huh?
I write to him at page 116 here. 116, para 19. We request that we may be given justice and the orders may kindly be passed within 7 days of receipt, failing which will be left with no option but to bring this to the notice of the Honorable High Court for necessary action and relief. Page 139, Commissioner writes to me that sorry, we did not receive the order from the High Court. And now that you have pointed it out, I'm releasing the money.
Then
So the money was released. Now the balance money of 13.45 crores for the other periods is due. Let them sanction it to me.
13.5, this is in respect to page 21.
Yes, Your Lord. So 13.45 crores in terms of the Supreme Court judgment.
Now they are trying to, now these amounts,
They have,
are they trying to appropriate, recover, or is it the case that they are trying to not
Both.
pay you?
both. They are trying to recover as well as adjust wherever they could adjust. Even against demands which have no relevance to this matter at all here. Lordship, I pay almost about 1,100 crores every year of tax. Out of which all I'm asking is, sir, this amount you should not have recovered in terms of Supreme Court judgment. So I'm only asking for 13.45. And once I put them under threat of contempt, which I normally don't like to do, they're all very bright officers. But what to do? When you sanction in terms of Supreme Court judgment, you've given it to others. Please give it to me. I don't like to come to the High Court for contempt. So they sanctioned me 9.45 crores. 13.45, I don't threaten them again. And therefore they have withheld that amount. Give it to me in terms of the Supreme Court judgment and the top same judgment in this. And you take your time in Supreme Court, you win. I'll return to you within 2 weeks. No issue. Within 24 hours, you'll have the money back.
So there was a show cause proceedings. Was a show cause proceeding prior to this 31/3/2023?
Prior to, yes, Your Lordship, there were show cause notices issued. I did not challenge them like others did.
You participate.
I replied to him to show to him, to sir, please, you cannot recover this. In under 11A, you can recover only erroneous refunds. This is not an erroneous refund. So he kept pending. By that time, Topsem came and Keshri came. So I cited before him. Please now follow the division bench judgment and the single judgment. Please do release the money. So he passes this order, noting both the judgments of this High Court. With great respect, Your Lordship, some message must go that when the High Court passes an order, they must comply. This is clearly in the face of those two judgments of the High Court. And now Supreme Court of Law. It was not before him.
Yeah.
And he still.
Issue notice when?
After 2 weeks.
2 weeks you won. Don't ask for just good. When? Give me a realistic date. You're not going to file the affidavit within 2 weeks, are you?
No, Lordship, by instruction I can obtain.
Would the instructions be would suffice?
Ultimately, affidavit is to be filed.
Then when?
4 weeks. Sir.
Issue notice making it returnable on 11th of September.
Lordship.
Matter will be listed on 21st, if convenient, after he files.
11th of September.
He can reply, file affidavit till 11.
We'll see on that day.
The matter will be fixed on 21st, if convenient.
We'll see on that day. We'll fix it on 11th of September. Mr. Esikal represents the respondent numbers 1, 2, and 3. Extra copies of the writ petition be served upon him by 31st of July 2023.
They already served.
The case of the petitioner herein is that the petitioner was sanctioned the following amounts by refund orders dated 2/4/2019, 7/6/2019, 18/6/2019, and 19/7/2019. The details of which are herein under page 21 of Charter Constitution. It is the case of the petitioner that the said sanction amount, the said amounts were sanctioned in view of the judgment of the Supreme Court in the case of MS SRD Nutrients versus
Commissioner of Central Excise, Guwahati.
versus CCA reported in 2018 1 SCC 105. When was the show cause notice issued?
6th of February 20.
Pursuant thereto, on 6th of February 2020, show cause notices were issued upon the petitioner as to why the orders of refund should not be cancelled.
No, why the refund amount should not be recovered under 11A, being erroneous refund.
Show cause notices were issued on 6th of February 2020, thereby asking the petitioner to show cause as to why the amounts which have been
Thank you.
sanctioned should not be recovered from the petitioner on the ground that the said amount was sanctioned or on an erroneous application of law. The petitioner participated in the said so-called proceedings and submitted replies. In the said so-called proceedings, the petitioner placed reliance upon the judgment of the coordinate bench of this court in the case of Topsem India, MS Topsem India versus Union of India and others. Judgment and order dated 12/3/2021 passed in MS Topsem India versus Union of India and 3 others. Rendered in WPC number 2918/2020. Wherein the coordinate bench of this court you are referring to a particular paragraph of the judgment.
Para 72 is the final.
No, not 72. 72 is the last paragraph.
Yes, Your Honor.
No, not that. Prior to that, you were referring to one paragraph yesterday.
Yes, Your Honor. Para 46.
The coordinate bench of this court where is the finding on this?
Findings begin at para 44 onwards. Para 45 is quote the question, then 11A. And yesterday I pointed out to my lords, para 46 onwards.
Wherein the coordinate bench of this court had observed at paragraph number 54 in similar circumstances that the refunds granted earlier cannot be considered erroneous, to invoke the powers under section 11A of the Central Excise Act 1944 only on the premises that the judgment of the Supreme Court in the case of MS SRD Nutrients Private Limited, Supra, have been held to be per incurium by the Supreme Court subsequently in the case of MS Unicorn Industries Private Limited. Versus Union of India reported in 2023 SCC 492. The petitioner had also relied upon the judgment of the division bench judgment of this court in the appeal division bench judgment of this court in the case of Union of India and others versus Kesari Enterprise. Reported in, what is this reporting?
2021, volume 10, TMI 484. Writ appeal number 162 of 2021.
In the case of Union of India and others versus Kesari Industries and others, reported in 2021 6 GLR 348. আৰু আগৰটো টপ চেম যোনটো লিখিলে 2021 3 GLR 412. Huh? However, the responding authority, it is relevant to take note of that the division bench of this court in the case of Kesari Industries had observed that irrespective of the fact that MS SRD in Nutrients Private Limited, Supra, have been declared as per inquirium by the Supreme Court in the case of Unicorn Industries, Supra, the matter had attained finality between the parties in as much as the order passed by the revenue for refund of the amount have not been challenged, nor the order of the single judge by which the learned single judge had directed that in view of MIS SRD Nutrients Private Limited, Supra, the amount should be refunded. It was further observed that the said that a matter having attained finality, the same cannot be opened even though MS SRD Nutrients Private Limited, even the judgment rendered in the case of SRD Nutrients Private Limited, Supra, have been declared as per inquirium by the Supreme Court in the case of MS Unicorn Industries, Supra. The respondent number 3, in spite of the above two judgments passed by the coordinate bench of this court as well as the division bench judgment having been placed, passed the impugned orders, passed the various orders on 31/3/2023, which have been impugned in the instant proceedings. Being therefore aggrieved, the petitioner has approached this court by way of the instant petition. Your name?
C.S. Lodha, Your Lord.
Mr. C.S. Lodha, the learned counsel appearing on behalf of the petitioner, apart from drawing the attention of this court to the judgments passed by the coordinate bench in the case of Topsem Supra Limited, Topsem, MS Topsem India, Supra, as well as Kesari Industries, Supra, have also drawn the attention of this court to a recent order passed by the division bench, passed by a recent order dated 4/7/2023, passed by the Supreme Court in the case of Commissioner of GST, CGST, and Central Excise, bracket J&K, bracket close, versus MS Saraswati Agro Chemicals Private Limited. Yeah, I bet and relied upon and submitted. That the subsequent decision and submitted that the Supreme Court had observed in the said judgment, said order, that the subsequent decision of the Supreme Court overruling SRD Nutrients Private Limited, Supra, in the case of MS Unicorn Industries Supra, cannot have a bearing on the past decisions which have attained finality, although they had followed SR Nutrients Private Limited Supra, which was subsequently overruled in MS Unicorn Industries. The learned counsel for the petitioner further submitted that if the said action which have been impugned in the if the actions which have been impugned in the instant proceedings is allowed to be perpetuated, it would open a Pandora's box, which would be against the public policy. This court have heard Mr. S.C. Kyle, the learned counsel, appearing on behalf of the respondents also, who submits that he would file an affidavit in the instant matter. Upon taking into consideration the judgment passed by the coordinate bench in the case of Thompson India Limited, India, MS Thompson India, Supra, then A2, Kesari Industries, Supra, as well as the recent order passed by the Supreme Court in the case of MS Saraswati Agrochemicals Private Limited, Supra. This court is prima facie of the opinion that the actions, that the impugned orders have been passed, impugned orders, the orders impugned in the instant proceedings, all dated 31/3/2023. May require intervention by this court. Accordingly, this court therefore states the orders at page 42, orders dated so and so till the next stage.
That's it.
Leave it to your lordship.
Till the next stage.
Very well. Disbursals can be ordered, I'll refund the whole amount in 3 days' time. Your lordship, others have got the money back. I only participated as directed by your lordship. The balance amount can be refunded to me. If they succeed, within 48 hours, money will be back to them.
That is not your prayer also here.
No, that's true, your lordship. But prayer is to get the whole money back.
Understood. We'll look into it when the next time comes.
Of right. A little accommodation if possible, 21st instead of 11th. I'm out of the country, your lordship. If possible.
We will see on that day. Mr. Sahewala can very well say, let them file an affidavit.
All right.
And our GST officials or the centralized excise official take signs.
Very well. Very well. Extremely great.
Item number 10,
Yeah, did you get it? Yes, Mr. Barbudari. Yesterday I was looking for you for this matter. What do you have to say?
My lord, the pleadings project that my lord, they are paying Bedokali Jarimona. And it is being collected by the Mozadar. Now, Radhakano comes into play, my lord, it says that Rule 16 prohibits. And notice also has been issued here, my lord.
Where notice has been issued? No notice.
My lord,
Oh, that notice has been issued.
that notice has been issued. Not a case for interference by this honorable court.
What do you say about the division bench in on 10/2/2000?
It is there, my lord. But then Rule 18, my lord,
Understood, but then also the division bench passed this order. What to do?
my lord, in that PIL, in that Suomoto PIL, my lord, in all the sequential orders from day
No,
one.
no,
till-
no, no, Mister. You have not got the right order. You have filed PL 6. PL 6 of 2011.
6 of 2011.
That is, there is the order where it is. Order to election. Isn't it PL 6?
my lord, it is PIL 10 of 20.
No, not 20.
And
That is that order of 22, 10/2/2023.
my lord, it is Suomoto PIL 10 of 2018.
Head to election. Order 2. The order is dated 10/2, na?
6
6
6-2.
6/2/2000.
In that PIL, my lord, that order appears to be the only solitary order amongst all
But
the
that is,
orders.
but that is the only detailed order.
That is the detailed order. But there, my lord, in my respectful submission, honorable division bench have ipso facto not, my lord,
But now in this
translate
case,
into the domain of order.
in
my
this
lord.
case, the division bench has an earlier set of writ petitions which was before this court. There was a mention before the division bench, and the division bench has asked that the single judge needs to take into account the orders passed in the said PIL.
Yes.
Now, this matter is for the first time. Now tell me what is.
That PIL along with that DAG 97 writ petition which my lord was dealing with, and my lord was pleased, my lord, to place it before the division bench. All that bunch of cases were listed yesterday before the honorable division bench, my lord, comprising of honorable chief justice. And my lord, the honorable division bench yesterday by order, my lord, was pleased to segregate the writ petitions, and my lord relegated the same, my lord, to the single bench, keeping only, my lord, that PIL and one, my lord, writ appeal, my lord, arising out of an order passed by the honorable single bench pertaining to, my lord, that Sinsaku case, my lord, that Rupjuti Bora Borgohai, my lord, common order.
There's one matter which has been done by Mr. P.K. Roy Chaudhary,
Yes,
where the issue is as regards the notice.
yes, regards the
What has
notice.
happened to that?
Yes, that is, my lord, that also I have, my lord, that is writ petition 1057 of 2022. That is, my lord, Mohammed Salekuddin. But that was placed, my lord, before honorable division bench comprising of honorable Mr. Justice S. Siam, my lord, and A.D. Soduri. My lord, honorable
But they
Justice
have
Siam has
recused.
recused. Honorable Justice Siam has recused.
Because he has passed that order in the other matter, Silkaku or something.
My lord, that Taher Ali order. My lord.
Then,
Now, after that, my lord, this writ petition has not been listed. But in that writ petition, the issue involved is whether notice is required at all to be, my lord, issued under order, my lord, under rule 18. Rule 18 ipso facto has not been challenged in the writ petition. That is only a, my lord, offshoot. Now, rule 18, my lord, was directly challenged before the
no, Mr. Bhattacharya, I'm giving you all these materials, what is required to be done.
this matter, my lord, this is a PIL, my lord, this pertains to, my lord, that eviction drive in Goluputi,
Hmm.
my lord, in Dorong district.
Hmm.
There, if my lord comes to my lord, page 3.
How can rule 18 this thing? This is under the issuer. The premises is humbly prayed that issuer rule adequate compensation to evicted person under the
prayer
Assam public premises.
Prayer number 4, Roman 4. Issue an order declaring the provisions of Rule 18 of the rules under the Assam Land and Regulation, Regulation 1886 as unconstitutional.
Where?
My lord, page 3. Page 3, my lord.
Prayer 4, Your Lord.
Page 3, my lord, is the part of the
Paragraph?
paragraph 2. Paragraph 2 begins.
So you are giving which one? The order passed on 17 to 2023.
Yes, my lord.
PL 76.
Yes.
Yes, where? Paragraph
PL
2 is where?
Paragraph 2, my lord,
The
will
three
find.
lead petitioners, so and so, represented by so and so, are
Lordship will come
concerned.
to the next page.
Yes.
Next
Yes.
page. Next page, my lord, in italics.
Ah,
In italics, Lordship will kindly come to Roman 4.
hmm,
That was the prayer. Amongst other prayers, this was one of the prayer.
hmm.
Issue an order declaring the provisions of Rule 18 of the rules
Hmm.
under the Assam Land and Revenue Regulation 1886 as unconstitutional.
Hmm.
Thereafter, my lord, the Honorable Division Bench, my lord, that was a case, my lord, where they pleaded that instead of resorting to Rule 18, authorities ought to have, my lord, resorted to the provisions of, my lord, the 1971. My lord, eviction from
Public premises eviction.
yes,
of
my lord,
unauthorized-
eviction of, my lord, unauthorized occupants from public premises. That argument has been negated by the, my lord, Honorable Division Bench. Lordship may kindly come to paragraph 12. Before that, paragraph 11, my lord, at page 11.
2021.
That is Rule 18 challenge on another ground. This has no relevance.
Ipso facto, my lord, not directly, my lord. Has been
Perfect. No, not directly. Nothing has to be done. Now, what do you want to do, Mr. Pothak?
Lordship,
Did you get that order? Alek? That is sumoto PL. Sumoto PL.
Yes, my lord, that is,
PIL, there is another number of that. This is sumoto.
that
This,
is 10 of 2018.
yes.
yeah, and-
এটা is the total detail.
Yes, Mr. Pothak, look into this. This is what may help you. But this is a case where you need to challenge Rule 18
Right.
because Rule 18 there, that is the problem. People keep on challenging things without properly doing the matter. They challenge it on the basis that as you are having 1971 Act, Assam, this Public Premises Eviction Act, therefore Rule 18 has been, but not on the ground that how the Rule 18, more particularly if the land does not fall within this. Now you see the observation in the italics.
No.
Now, have you asked for settlement?
Lordship, we have your lordship, and
When?
in fact, so far as the one of the petitioner, your lordship, we have the document.
They have only made a solitary statement in the writ petition as well as in their representation. There is no materials, my lord, to corroborate that statement. They say that, my lord, they have applied for that Basundara scheme.
Lordship, that
Page
is-
29 of the writ petition, my lord. It's a part of their representation, page 29. My lord, paragraph number 2.
Where is the land?
Land, your lordship, is at
My
Bonda,
lord,
your-
Bonda.
Bonda,
Bonda.
Bonda,
So it will come under the urban area.
urban area.
Yes, Kamrup Metro.
So your right will be only limited to one kata or something, na?
One cut of 5 lakhs.
One
Under
cut of 5 lakhs, sir.
2019, your lordship.
And how much you are in occupation?
Well, there are 4 petitioners altogether.
How much you are in
Not more
occupation?
than your lordship 1/5.
Huh?
That is also precisely not spelled out in the writ petition. Quantum of land. The quantum of land under their occupation is not spelled out in the writ petition.
The chief justice has told me that he will give me bench one, then you make these technical submissions, not in this bench. Yes. Yes, how much land, Mr. Botago?
Lordship, one person has only 15 letters, your lordship.
And the
One
other,
person and others, your lordship, I am.
you have not mentioned anywhere how much land you are in occupation.
Lordship, I see.
Neither in the writ petition nor in their representation.
And when did you file your application? These details have,
Lordship, I will file an additional affidavit. Your
what happens, but I'm not going to stay.
Or your lordship, in terms of this judgment.
Sorry, not that. That judgment is there. I have helped you, but for the purpose, you have to make out a case for that.
Lordship,
You see, that judgment is specifically, I'm asking you various questions, only for the purpose of helping you. I'm asking you the settlement because they have asked for settlement there.
Right.
And that is why it has been asked. Now you have not mentioned anything. How do I help you?
Lordship may not pass any interim order. Your lordship may fix it on Wednesday, your lordship. I will come up with an additional affidavit, your lordship,
Hmm.
bringing in.
Now you have seen the judgment.
Lordship, I have.
What is required to be brought?
Lordship.
Issue notice, making it returnable on fourth.
Lord.
Issue notice making it returnable on 4th of August 2023. As the respondent numbers 1, 2, and 3 are duly represented, 1, 2, and 3 are duly represented by Mr. R. Pujari as well as Mr. N. Goswami. Extra copies of the writ petition be served upon them during the course of the day. Full stop. The learned counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit bringing on record further additional material and details in respect to the details which may be relevant for the purpose of disposal of the instant writ petition. He is given the liberty to file such additional affidavit by 2nd of August. The learned counsel for the petitioner further submits that he may be granted an interim protection. The interim prayer shall be taken into consideration on the next day.
Deeply okay.
But it is a case for disposal.
Item number 8,
Yes.
My lord, Mr. A. Chaudhary, my lord, he is the engaged counsel. He is laying in court number 6, my lord.
Who is
My
in?
lord, take it up after some.
Oh, itu Bishop Lock. Upon Bishop Lock. That one.
Yes. Getting bank.
Did you find anything?
My lord.
You see, Mr. Counsel, that counsel may not help you. He may help you. Yes, did you find anything?
1 or 2 cases,
No. How can we give him the pension?
pension, no one.
There is a regulation
Yes.
that if a person is dismissed, he is not entitled to, he
Past service
forfeits.
will be forward.
No, do you have a regulation for this?
One part is there, some compensatory amount may be there, but that is not a matter of right. That is also decided by the Supreme Court.
So we can ask that to
Maybe.
pay that
And that
compensation.
has to be applied before the higher authority, the authority who has passed the.
Whatever may be, forget about him applying it. This court can very well direct the authorities to consider about
Yes.
payment as per its existing policies. We'll take it up after some time. Yes.
Apply.
item number 1,
May I please, your lordship?
Hmm. Yes.
I prayed for a legal accommodation for today, my lord, in the morning, my lord. As the engaged counsel are from Bombay, my lord.
Yeah. Yes. What is your case?
My lord, there is an impugn, my lord, the impugn order is that page, my lord, 85, my lord, the effective portion will find, my lord, page 85, my lord.
What are you challenging?
My lord, there is a demand notice issued by the, my lord, respondent authority.
Impugn order dated 25/3/2022 passed by the respondent number 2 is ultravirus the provisions of so and so without any authority in excess of it. This is an order being passed by respondent number 2. Who is he?
The Principal Commissioner Lordship. Yes.
My lord, the,
Principal Commissioner.
Yes.
Now, whether an appeal lies,
my lord,
unless you come within the ambit
Right.
of the exceptions on which this court requires to decide this matter
Right.
under 226, and it is not an efficacious remedy,
Right.
why should this court at all consider your case?
yeah, on that point, my lord, last occasion,
Huh?
my lord, on that point on the last occasion, my lord, matter was taken regarding the maintainability.
Yes, I am also asking
My
on
lord,
the
yeah, my lord, regarding, my lord, that, my lord, the engaged counsel wanted to place some judgment, my lord, regarding the whether is this case is maintainable under Article 226 or not, my lord. The other judgment is passed, my lord, with us earlier, my lord.
which
But-
one?
Some of the
Now,
judgment.
you are challenging an order
My lord.
passed on 25/3/2022.
Yes, my lord.
An appeal lies against
Yes,
it.
sir.
To
To Lordship, CSET Lord.
Siget.
Lord.
Then
Lordship.
Siget is nearby to your councils, isn't it?
Yes.
Bombay.
Bombay.
Similar matters, Lordship has passed order that was upheld by the division bench also.
Oh, is it?
Yes, sir.
Interesting.
That's why, my lord,
Okay. In view of the matter and taking into consideration that there is an appellate secretary who can adjudicate the issues involved in so and so, submitted at the hearing that the email has not been considered by the other. This contention can well be adjudicated by the appellate authority. Okay. So, down beyond the field of government. So, nothing remains.
therefore, my lord, I find it one that maybe it can be disposed of, my lord, on that point, my lord.
Chalo.
The only ground of maintainability will argue, my lord.
Tomorrow, 10:30.
My lord, kindly,
You said one day.
my lord,
Matter over.
my lord,
10:30 tomorrow.
my lord, Monday, my lord, is it?
Tomorrow, 10:30.
Okay.
Yes. I do. Khalid, tomorrow, 10:30.
Interim order, my lord.
Tomorrow, we'll see.
Obliged, my lord.
Matter today. Yes, Mr. Burawai, your matter. Hey, couldn't log out. Matter. Yes, what did you find?
Lordship, for one document, there is instruction of the.
I custom check only. Yeah. What is this? Regarding the rampant under invoicing of raw and semi-processed human hair. So,
Paragraph 2, Lord.
rampant under invoicing in export of raw and so human hair with export of human illegally to Korea and South Africa. and then further in final also cited in the third circular. From the principle of subsequent measures regarding the payment writing. Submitted in Oh,
It was the reason to believe lordship for seizing the material by the custom department. And on last occasion, lordship had produced the record before seizing. Lordship, this was the reason to believe of the officer for
where is the reason to believe?
lordship on the last page of
The
the
last page is only an information
yes, information.
that he may sell it to More. That's all.
Yes, lordship. that-
And there are, that's the only information. These are nothing which are the basis of information that there is the less of custom duty and all.
No, lordship, this is the one reason, lordship, the main reason is for illegal export of the human hair.
But how do you say so?
Lordship, first page of the note sheet, lordship, let me kind with it.
Acting on the intelligence on demand, the officer of anti-money conducted a choice operation at on the platform, verification in presence of three indirect on the in the so there's nothing.
This is the reason behind lordship. Lordship, now I can submit lordship under section 110, capital A. Provisional release can be made to the actual owner lordship. The goods can be provisionally released to the actual owner lordship. In this case, lordship, I want to place paragraph 10 of page 44 of my affidavit. As I informed lordship, that is still pending. As he page 44, paragraph 10.
With regard to stated, the request for provisional can be entertained from the actual owner in the instance that has not. You are still holding that he is not owner.
Lordship, that's why lordship, because he produced some documents which were not matching with each other.
Well,
That
which
was-
is not matching? Tell me,
Lordship,
which is not matching?
here lordship, it is stated in this
Huh?
paragraph. In this paragraph, we have stated lordship.
Yes.
In the instant case, the Kitab Ali has not been able to prove his ownership beyond doubt. The documents are verified, and it was found that all the documents are photocopies. Among some of the finding, it is worth mentioning that Babul Sarkar submitted copies of 2 numbers of invoices issued to Kitab Ali against the same consignment, which does not match with each other. Further, the said invoices do not match with one of submitted by Kitab Ali against the same consignment. which proves that the said documents are either fake or baseless. Therefore, the Kitabali has not been able to.
Now let us see which are the documents you are mentioning.
Probably that is available in the record also.
No, here we have it here. No?
Lots.
Babul Sarkar's letter is here. Where is it? It's seen it somewhere.
Page 55. Lord.
Page 55. Yes. Now this is Babul Transport. Human hair HSS 4440, quantity 356, rate 4,000 there, total 16,000 so and so.
No.
Now let us see the GST invoice.
That is by Srishti Enterprise. Lord.
Page. No,
Page
it is here.
56.
Now kindly see page 25. This is being given to Babul Sarkar,
Lots.
road challan.
Lots.
Total is same,
Yes, lots.
so it is to go from here. Then you see the next page. Makali Enterprise.
Makali Enterprise.
Human hair 16 packets 356. Amount is total is 10,680 is the transportation cost. Okay.
It is from Sialda to Guwahati. Lord.
Huh?
Sialda to Guwahati.
But this is transportation cost 10,680.
Yes, sir.
Then you see by the railways. This is the railway receipt voucher.
Yes, it is in the name of Srishti, Sialda to Guwahati.
Srishti Enterprise, who had actually issued that particular document, the GST.
But here it is not matching in the railway receipt. Lord.
No, wait. Huh?
There is no match in railway receipt. Lord.
Srishti Enterprise, so they will be here also be the supplementary bill against the so and so railway board so and so. Supplementary bill of so and so, value of so and so, declare value, mobile number of so and so, GST and then you see Srishti Enterprise GST thing. Kindly see Annexure 12, page 33.
Page 12.
This is human hair total value 16,37,000. How much? 16,37,600. Invoice number so and so 25/5/2022. And this is the payment of. This is details of the receiver is Kitabali, Indian Hair, Jalukbari so and so, GST number, and consignee is Babul Sarkar.
Consignee is over.
Then what is there? You are going to send to Lalchan Sheikh. Lalchan to Rebul.
He's also a registered my lord
Exporter.
dealer in human hair.
Okay.
He is also exporting hair.
Okay, Mr. Buragoy, you know that Rebul, he has given his statement somewhere. Where is it? I saw it something. Somewhere he has given some statements.
Yes, Lord, sir, that is available on the record also.
Kitabali, full address.
Lalchan Sheikh was supposed to sell to Raibul Chand.
Trade registration numbers and so.
Anyway, my lord, I have given all the information. They have
Kitabali
and
registration
they have verified it, not
certificate.
only here.
He has also, Kitab also, Ali
Yes, ma'am.
also has a registration certificate for Indian hair.
Yes, Lordship, yes.
So he has that. Then Kitab Ali is going to, and in his income tax also, he has given
Yes, my
that he does have. Then where is the statement of this person concerned?
We have.
They have verified all these things, man, here and Calcutta in both of it.
Understood?
And
No, no,
I-
yeah, wait, Pradeep
Whatever
Kumar
he-
Mishra, statement of Pradeep Kumar Mishra, who is he? Srishti Mishra, Srishti Enterprise. Now, what does he say here? How are you doing? So I, Pradeep Kumar Mishra, am giving the statement today. Before giving the statement, the customer has explained to me about so and so, so and so. In continuation to this, I would like to state about the matter of teaser of so and so, that the relevant document known about the matter may be provided by the owner of the Iman who is currently out there and will return. I would ask the owner to come to the office. I have nothing more to say. And again, he comes out, they introduce himself, what is your name? We are authorized leaseholders on Selda division of so and so. Do you come? Yes, Iman, you have come. Yes, I do. After collecting human hair from Babul Ali, we have sent it to Guwahati by our lease parcel van. I do not have any documents regarding receipt of the sale on as my accountant is on leave. Receipt to certify has been registered under so and so and have registered themselves as so and so. History and plan. In this connection, I am requested that you to allow my husband so and so. Ram Babu Yadav. Who is he? Ram Babu Yadav. 60. History is a transporting agency.
Yes, sir.
Transporting.
You purchase from Babul Sarkar.
No, actually, my lord, your lordship will, it will be made clear, my lord, if your lordship, see their affidavit.
Hmm.
Pays, my lord,
Page 53, question number 4, Lord.
my lord, page 52. It is a.
PGP in reply.
Yes, 53, yes.
Page 53.
Yeah, why you,
Question number 4, Lord.
1 to 3 for everything, man, you can get right, very short.
From where have you collected? This is by whom?
By me, my lord, Kitab Ali,
Okay.
by the customer.
The
officer.
human hairs are collected from Murshidabad from door to door and small shops by local ferry and handed over to my shop. I purchased the said goods from them and stocked them in my godown in Indian Hair Murshidabad. After that, I transport the hair to Guwahati. I have submitted the GST certificate so and so, and GST invoice issued by Babul Transport. So all are transport.
My lord.
So it is you who have procured it from
Yes,
there.
madam. And through the transport, it has come to the
Guwahati.
Rialdo railway station. From Rialdo, it came to Guwahati. And Guwahati at that time, I could not, my agent could not be there. So it was dumped in the platform number 4. Actually, that should have been there. But after that, the railway authority would have taken it to the godown. But they have intercepted that and they said that it is these are without any owner, so we confiscate it. And they cannot confiscate it in Guwahati, my lord.
Let us see this Raibul Chand. What does it say? What is your profession? What is your on Wednesday, the officer of so sees you and so. No, I was informed recently. As mentioned in his statement that he was planning to sell the goods to Lalsan Singh. Besides, Lalsan mentioned he stated that he was planning to sell that to you. Yeah. Yes, I know both of them. Yes, he told me that he will be bringing 16 bags of human hair. For what purpose were you planning to use? I trade in human. I buy human hair from the local ferry hawker and sell it to local. But Lalsan did not bring the said 16 bags to me. I got my registration. I have submitted copies of the registration of how many times have you purchased here? I have never purchased any human hair from Lalchan. Do you have any other things? My response in Hindi language to the above questions were recorded on the instrument and explained to me. Now this is by this rebel child. What was the customs duty? Why are you in? I was summoned by so and so. Well, yes, I know. Kuresi exporter. What is this Kuresi exporter doing this? Yeah, traders, so and so, type of registration, so and business of contract and supply, import and export, name of the so and so. What is the business it does? Plastic goods and hair store. Name of the what is this? GST and he has a registration of Raibul Chan for human hair.
Not same. It is
And Lal Chan says, and yes, I know him since last 4 years. His house is about 3 kilometers from mine, and we came to know each other. Yes, I was planning to buy the said goods from him. So Lal Chan Sheikh says that he is going to buy from him.
yes.
Kitabar.
It is taken.
In what purpose were you planning to use the? I was planning to sell the said good to Raibul Chan AR Traders when he's a trader of human hair in Guwahati. Since when have you came? This is my first time. Came to Guwahati in Iman in search of work, and as I am not able to get any. Now, Mr. Kyle, he says that he is going to sell it to Lalchan. Lalchan says that he is going to sell it to
Another.
Raibul. Raibul says that he is going to sell it in the local market.
Okay.
After that, what further means? How can you further stop it?
Lordship,
It may be a thing. I
No.
also understand one thing that it may be false because here you see Lalchan have never done this business earlier.
yes, he said that for the first time he is.
Lalchan says that I have never done the business. Raibul also says that I have not done business with both of them earlier. Because his statement here says, but yes, Raibul also says that I am going to purchase it.
Yes, he is taken.
Because he says, yes, I have never purchased any human hair from Lalchan. So he says, Raibul says that I have never purchased from Lalchan says that I have never done business earlier, but now I'm going to do the business, but I know this. Now, how do you protect something to that effect?
No, Lordship, there is no market.
But the fact that on these facts you can confiscate also,
Lordship, that is another aspect of the matter. Lordship.
because if you can seize only what you can confiscate.
Yes, Lordship, that is correct.
Now,
That's-
can you confiscate something which is so far away from the border of More, because the specified area happens to be 100 kilometers?
Yes, Lordship, that is correct. But
How
Lordship,
do you take it? Come, think about it. I'm coming in 5 minutes.
department's contention, he could not prove his ownership, and his application for provisional release is still pending. Lordship may direct the authorities to take all on that, and after verifying the documents, consider his application under section 110 capital.
What document you require for him to prove?
No, Lordship,
The fact that he has brought it from there, he collects various
He
human
collected.
hair.
and he said that he dispatched, but the document shows that it was handed over to some transport company, and he was the concerned here.
Now, he has given it to Srishti Traders.
Traders. Look, Bob,
It's only my
Lordship,
lord, 60, your lordship, kindly 3, page 53, question number 6. He has said everything there. It is the first time, my lord, he has said, he has sent to Guwahati.
Yes. Question number 6.
Question number 6. How many times have you transported human hair to Guwahati? How did you transport this thing? This is my first time. I booked 16 numbers of so-and-so bag for transportation to Guwahati through Papul Transport, copy and close. The goods have been transported through railway parcel by Srishti Enterprise, Srishti Transport to Guwahati. I have submitted the copies of the transport in my application. Later on, I have to collect the goods from Guwahati Railway Parcel office. But I came to know that the goods have been seized by the customer. So this is the first time, my lord, transaction, and he has given all the documents before them. They have examined here, they have sent it to Calcutta, all of them to Calcutta, the transporters, Babul and history, everybody went there and they have been examined, cross-examined, they have given the statement. So what remains, my lord? The genuine transaction, they have all the documents, and your lordship has also pointed out there, 11 East. See, it is not seaport, Guwahati cannot be seaport. They do not have the jurisdiction to do that. And also when I have got some judgment. Well, it is a simple case, they are making it very complicated. And
But these goods are not prohibited.
restricted.
Restricted is different, but restricted is not there out here in the
for my knowledge,
113.
restricted means I will have to inform the customs where from I have collected it and whom I will sell. That is only.
But
And
it has to be within the,
my lord, these
specified
are
area.
the papers I have given to them.
what is
And they have
that
examined.
section I have given you yesterday?
113 Lord.
My lord,
No, I gave you a section, no?
yes, 11 H3. In my book, it is, my lord, page 14. Retention or
include the Indian
Limitation of
custom
illegal
waters and
export
such
of goods.
inland area not exceeding 100
See
kilometers
the
in width
relevant
from
section
any
is
coast
your lordship
or
of the-
other border of India, as the central government may, having regard to the vulnerability of that area to smuggling by notification in official, provided that where a part of any village, town or falls within a specified, the whole of the month shall, notwithstanding the whole or any part is within 100 kilometers from any coast or other border of India, be deemed to be included in.
There is no customs report within 100 kilometers. This that side, my lord, in the Shillong side, 100 kilometer will be Borapani, and this side, my lord, Mure, it is more than 1,000 kilometers from here.
600 kilometers from the border.
Okay, then Mure. All
600.
right, I don't know. Then also it does not come within the expression 100.
And they have to cross through Manipur.
Yes.
Yes. Accidentally, they have, it was in the platform, so they have come and got it. Otherwise, after some time, the railway person would have got it and put it in the government, railway government.
What is this custom area? Is there any mention of any custom area here in the act? Custom station, means the area of custom stations or warehouses and includes any area in which imported goods or air or ordinarily before clearance by customs. And these are not specified goods.
These are not specific, only the notification received by the Ministry.
This is under that foreign thing.
Lordship, that is not notified under section 123.
Or no, it is not notified under section 11(I).
Lordship,
These are not specified.
only as per the direction of the Ministry of Commerce, Lordship. This is earlier it was free goods.
No, then if it is the direction of the Ministry of Commerce, then you have to see why it is a restriction.
Yes,
The-
Lord.
Because that day I was going to, when the Ministry of Commerce gives a restriction, the reason for restriction is that they want to have in India the particular industry. And because of the export being made, that industry cannot prosper in India.
No, that is Lordship another thing. But here in this case, there was a complaint from different quarters that human hairs are being exported illegally and under invoice are made. Lordship, mainly the market is in Myanmar, Lordship. That is reflected from the documents I have submitted to you.
Market is not in Myanmar. Market, the manufacturing may be in Myanmar.
Yes, Lordship. In other words, Lordship. And Lordship, paragraph 13 at page 46, that will also give light, Lordship. Here, the petitioner was informed. Page 46, paragraph 13.
Yes.
that with regard to the statement made in paragraph 16 of the writ petitioner, the answering respondent state at the place of detention seizure, that is Guwahati railway station, comes under the jurisdiction of the custom division Guwahati. Documentary evidence submitted by the petitioner being verified along with the report of investigation received from Calcutta, and the petitioner was well informed that the outcome of the application will be mentioned in the so-called notice orders shortly. The consignee is the petitioner himself, as in the records. It is nowhere mentioned that AIR Traders is the consignee in the statement.
Air Traders is Raibul.
Rival.
Obviously, he is going to sell it to Lalchan and Lalchan is going to sell it to Raibul.
No, but Lordship, they are talking
In
about.
fact, he was the consignor as well as the consignee.
Lordship, consigner is Srishti Lords.
No.
Lordship, please to see railway.
Srishti is not the consignor.
Railway receipt. Lordship.
No, he gave it to the Srishti. Srishti is the transporter.
No, Lordship, railway receipt. It reflects that the consigner was Srishti Lordship, page 29. Lordship.
Yes.
Consigner was
Who is the consignee?
consignee name is not reflected here.
Obviously, that is why, because he has given it to Srishti for transportation. Srishti becomes the consignor and consignee, and it is being done to give it to him. And that is why you have seen that petitioner is the consignee himself, as per the records.
Srishti cannot be consignee Lord. He may be his name is reflected as consignor Lord. Although there is no name, name of the consignee is not reflected in the.
Tell me one thing. I purchased some goods out there in Calcutta. I want to transport it out here,
Lordship,
to carry it out here to Guwahati. What do I do?
for general goods, there is no.
No, any goods.
Then Lordship,
Here, we are not concerned about the restrictive policy at the time of when it is in the railways.
he has to produce the receipt before the railway authority to collect the goods.
So he has produced that.
Lordship, he has not produced that. He has produced some other document. That is,
What document do you want?
the Lordship may direct the authorities to consider his application for a provisional release.
No. This is not a case of provisional now. Provisional means I have to keep the matter pending. He has challenged the entire action.
So this is the materials Lordship I produced.
Well,
And now Lordship 124 notice has been issued to him.
124 is for confiscation.
Confiscation.
But can you confiscate under 113? Show me that. You can't confiscate under 113 because you can seize anything which you can confiscate.
That is,
Now, if 113 does not come into the play, then how do you seize it? Or then under 124 you initiate action. Yes, Mr. Burama, you are relying upon these judgments. What are these?
My lord. But
One judgment I've seen it. This is a
Yes,
short
ma'am.
one. Yes, then
next one, my lord, para 8, where there, my lord, only thing that
coming to the alleged role of the respondent number 1, we find that the commissioner has imposed the order of payment of penalty upon him only on the ground that the goods were cleared for export by so and so. This can hardly be a ground to question the liability or attribute abatement on the part of so and so. Likewise, insofar as responsible is concerned, against him is that he has supervised the stuffing of the goods so and so. Only on him. Order directing release of constituent within the required to be.
There are 5, 6 are also my lord given in for lordship.
Now, you are only concerned that the petitioner have not been able to place any materials.
Sufficient documents to prove his ownership. Lordship, in the entire petition, the case of the petition without that the Jima should be given to him.
Huh?
Jima of the goods should be given to him.
Hmm.
Lordship may see to
Release the receipts retained
paragraph.
15 a month and hand over to the petitioner. So he wants the return.
Yes, return. Jima only. Jima.
So
Lordship,
if we direct return,
Lordship,
if I direct the returning, subject to something can be done. What can be done?
that under
Protect the interest, because tomorrow your only concern is he has not been able to prove his ownership. Now, if anybody else claims tomorrow, that is the only worry.
Lordship, one thing.
Not on the basis of the customs,
Custom.
because you can't confiscate your basic now as you are submitting that this particular documents he has not been able to prove his ownership. That is
Yes.
why you are not releasing.
As on date, Lordship, this is the.
That is it. So how do you protect yourself? Means tomorrow,
Lordship, under section 110A, he has to execute bond. Lordship.
bond is okay. Bond would not, tomorrow he is lost and found. What are you going to do with the bond?
No, this is the procedure. Lordship.
Let's see.
110 capital A. Lordship.
Provisional release of goods, documents and things seized or bank account provisionally attached. Any goods, documents or seized. What is the security? Bond is okay, but what is the security?
The section provides for only bond. Lordship.
No.
Security and condition.
Which secure such security and conditions?
Bank guarantee.
Bank guarantee, if he gives bank guarantees for businessmen like them is
Yes.
something like money only.
Lordship, with regard to ownership, Lordship, we stated in paragraph 15, page 47, when many persons came to the office of the custom claiming ownership of the goods. Once they were asked to produce the document, they didn't turn up thereafter.
That is the matter, my lord. They have come there, they have not any, but we have so many documents and we are the real owners, so we have given. Their own statement is contradictory, my lord. They say that we are not, then they examine our document. And those persons who claim, at least they have not given the names who has came there. The custom is that these are our, no name, nothing of it, only simply says that so many people have come. But they not, what is this? If a person comes to the custom office, he claims ownership of 16 bags worth about 16 lakhs of rupees.
But Mr. Burawe, why not give a bank guarantee
Yeah.
for a period of 6 months? If during this period anybody is able to satisfy that they are so and so,
Right.
that their goods are there,
Sure.
then in that regard, then that is protected. I think that is the best way.
Nobody will come, my lord.
No, it's okay.
I mean,
Nobody
if-
comes.
if you're
For
not-
that, they
if-
have to come to a finding.
Yes.
I think that is the best way.
I think-
So the value of the goods is protected for these 6 months.
Lordship,
And if you can't adjudicate and find out anybody else, then obviously it is his.
everything.
I think that is the best way.
Since 124
They
notice
will
has
have
been
to
issued.
release us. with
No,
good
obviously they will release you subject to a bank guarantee of the value of the goods so that it remains out there
Yes, sir.
for a period of 6 months.
Lordship.
And on the period of 6 months, then thereafter the bank guarantee will be invalid. If within this period they can't find any owner,
Lordship.
I think that will
I think-
serve the
Yes,
purpose.
Lordship. Thank you.
Chalo. I'll dispose it of today itself. You get your judgments.
Much.
I'll give you the records tomorrow.
Lordship,
But that is the only way out.
Lordship, I think.
Something has to be done because otherwise,
Much.
because it is a never ending process.
Yes.
Obviously, Lordship, we have to dispose of the
And-
124 proceeding within a specified period.
And-
That will do, Lord.
And the hearing.
124 is a confiscation. How do you confiscate something?
Lordship, if it is,
No, here the question of confiscation does not arise because of 113 is not applicable.
No.
Your only worry, and 113 can't be brought in because you can't bring in 110.
no, that is,
That is okay. But you are now worried about only one thing, that anybody else may come. So let him give a bank guarantee for a period of 6 months. If anybody turns up and you are satisfied, then obviously you can invoke the bank guarantee. Suppose it. You'll get the judgment.
Right.
Huh? I'll take up some other matters now. I'll dictate the judgments later today. Get the judgment tomorrow.
You're very much surprised, my friend.
Huh?
You're obliged.
Yes. Yes, Mr. Sahewala, your matter? You have filed a stay vacating. Let us take up your stay vacating. You come this way. The other side is going to come.
Yes,
You are the respondent.
yes, I got. My lord, the respondent means, my lord, actually, the tendering authority has not been a party.
Understood.
My lord.
So, Mr.
somebody
Sahewala,
else- Somebody else.
come here. Otherwise, Mr. Chaudhary will come here. Yes. I do file today. I do. Supplementary list. Right. I do. Item 13.
Number 30.
1 plus.
Wrong statement.
My lord,
1 muka tu. Yes.
my lord, this tender was issued from Vadodara. That is the GGM head WCN Basin. And they settle it, my lord. The headquarter.
Just 1 minute. Just. By filing the petition, I have still the decision making in technically rejecting the petitioner of commercial feed. Now that it's criteria for final sorting. Yes,
My lord, if your lordship will see
Hmm.
the course title 5 in the petition,
also title.
yes. Petitioner is Mahabala Operators Private Limited.
Hmm.
This is, they have said it is a registered company.
Hmm.
And ONGC, it is Delhi, presented by chairman. Chairman has nothing to do with the tender.
But ONGC's registered office is where?
Main registered office is at Delhi.
Where was the tender issued?
Tender issued from my lord Vadodara. That is, if your lordship turn to page 55, they issued the letters. GGM head, MM department, 155.
Hmm.
That is the tendering authority. my lord.
Where is the tender? Oh, GM.
Yes.
GM
GCM.
has issued the tender.
And it was settled there, but it does not come to the head office, my lord.
I've got in Assam. What does ONGC have?
No, I ONC Eastern region, Nazira.
What is that?
That is a region-wise, my lord, offices are there.
No. What is that office? It's a
Regional
registered-
office.
not a registered office.
No. Regional.
Then the tender was for doing what? Where's the tender for?
My lord, I'm- My lord,
Page 36.
yes.
Hiring of service for 3D
Yes.
seismic data
Seismic data.
acquisition in Narmada area.
Narmada in Gujarat. My lord, in fact, my lord, this has been given for 2 years by the Director General of Hydrocarbon to ONGC. And they have to complete this work within 2 years. My lord, no, 1 year already over. my lord.
Yes, Mr. Chaudhary.
Yes,
How do you satisfy the
yes.
jurisdiction, territorial jurisdiction?
My lord, first of all, it's a tender for my lord seismic survey. Now, yes, the work is supposed to be carried out in Gujarat. Tender is issued in the portal mine. So that way it can be said that the tender is issued from this place. When it is in portal, it is all India. Wherever the issue is, if I am to invoke your lordship jurisdiction under 226, I'll have to satisfy your lordships that at least a fraction of the cause of action has arisen within the jurisdiction of the honorable court. If I can satisfy your lordships, then in that case, I think I'll have the jurisdiction to invoke your lordship power. Now, if a lordship knows, if we go to the history of Article 226, initially, my lord, 1A was added. Subsequently, my lord, 2 was added. Subsection, sub-article 2. And if we look at the language of sub-article 2, my lord, it is exactly similar to 20C of CPC. That is, whether cause of action has wholly or partly arisen within the jurisdiction of the court. And Supreme Court has also said, my lord, the decisions rendered by the Supreme Court in respect of section 20C of the CPC will be applicable even in case of determining the question of jurisdiction in a 226 proceeding. Now, my lord, if your lordship would kindly come to page number 255 of the writ petition, my lord.
Yes.
This is a communication by the ONGC, the tender issuing authority, my lord, employer, to the petitioner. Kindly see, my lord. It is dated 18th of December 2022. to Mohabala Operations Private Limited, Provisional Commercial Complex, Ulubari, Guwahati, etc. etc. Your quotation submitted against Swens. So, my lord, ONGC has communicated with the petitioner as a tenderer at Guwahati. Then, my lord, at page number yes, page number 261, my lord. We replied to ONGC at page 261. Refer to your letter dated so and so. I'm not troubling your lordship with the subject matter of the correspondence, but the fact of the matter is they communicated with us and we replied. Similarly, my lord, there are other communications. Now, whether the two communications would constitute whether a fraction of the cause of action has arisen within the jurisdiction of the honorable court. Now, my lord, before that, I may draw your lordship's attention. First, I moved a petition before the Delhi High Court. Now, that your lordship will get, the order is at page 317. Now, I have instructions to submit, my lord. When the petition was moved before the Delhi High Court, their counsel raised an objection that it is the court at Guwahati which has jurisdiction. Please come to page 317. In fact, the last page of the petition. This order was passed in presence of the ONGC counsel, my lord. No. They appear. They appear. Learned counsel allowed subject to just exception. Learned counsel appearing for the petitioner seeks permission for withdrawal of the present petition with liberty to approach the Guwahati High Court. Permission and liberty as granted. Allowed merely because this liberty is granted, that by itself is not decisive of the issue. That for that I am not placing this order, my lord. I am placing this order for the purpose, my lord, that an objection was also verbally raised, my lord, on behalf of the ONGC that perhaps Guwahati Court has jurisdiction. That is how, my lord, we sought liberty and liberty was granted. So this is the background on factual side. Now, my lord, the government report is correct.
Reply.
Affidavit in reply. No? My lord will kindly come to page number 362, my lord. Page 362. Somewhere in the middle, my lord. Sentence start line about 1, 2, 3, 4, 5, 6, 7, 8, 9. Line about 11 from bottom. The sentence starting with, further during the said proceeding before the Honorable Delhi High Court, as per procedure, advance copy of the writ petition was served upon the learned counsel for ONGC. Though the name of the learned counsel for ONGC was not recorded in the said order, but he was present during the hearing of the case. The learned counsel for the ONGC has supported the observation of Delhi High Court that the Honorable Guwahati High Court is the appropriate court to adjudicate the issue, and as such, they now cannot raise the said issue before this Honorable Court. This is our averment.
But see the fourth line from the top.
During adjudication of the said proceeding, jurisdiction issue was cropped up, and the Honorable Delhi High Court has expressed that as petitioner's registered office is at Guwahati, the writ petition lies before the Guwahati High Court, and on the basis of the said observation, the petition was withdrawn with liberty. Yes, this also happened. Simultaneously, this aspect was also highlighted by the other side. In fact, there is a Supreme Court judgment, my lord, 84. It says, because my registered office is at Guwahati, I can approach Guwahati.
Who made that?
Yes, 1984, 2 SCC 4646. Paragraph 2, my lord, at page 648. Mr. MS Oswald Woolen Mills Limited, having its registered office at Ludhiana in the state of Punjab, and a branch office at Calcutta, and Narayana Das Jain, secretary of the company,
have filed a writ petition in the Calcutta High Court seeking various reliefs against the Union of India through so and so, the deputy so and so, the collector of etc. Primary prayer in the writ petition is to prevent or to quash an apprehended or purported action under clause 8b of the import control order. All other reliefs sought in the writ petition revolve around the principal relief regarding clause 8b of the import control order. The other prayers are either ancillary or incidental to the principal prayer or are an interlocutory in character. Having regard to the fact that the registered office of the company is at Ludhiana and the principal respondent against whom primary relief is sought are at Delhi, one would have expected writ petition to be filed either in the High Court of Punjab and Haryana or in Delhi. The writ petitioners, however, have chosen the Calcutta High Court as the forum, perhaps because of the interlocutory relief which is sought in respect of the consignment of beef tallow which arrived at the Calcutta. So Supreme Court has clearly said, my lord, because the registered office of the respondent was in Delhi and the petitioner is from Punjab and Haryana High Court, therefore either a Punjab and Haryana High Court or Delhi, this could have been, my lord, institute. Then, my lord,
This is done because of section 19 of the CPC,
CPC.
because the effect is felt. An order passed under section 8B would affect the petitioner's residence. If it is a company, the residence of the company is the registered office. That
No,
is why
correct.
it has been.
No, logic is correct. In that background, it was
It is in that perspective it
Absolutely.
has been.
absolutely. Now, my lord will kindly take the other judgment, which I am reading. 2014 9 SCC 329.
Yeah.
My lord will kindly first come to paragraph 12 at 337. In Kusum Ingots and Alloys Limited Union of India, this court elaborately discussed clause 2 of the article 226 of the Constitution, particularly the meaning of the word cause of action with reference to section 20C and section 141 of the Code of Civil Procedure, and observed as so and so. Although in view of section 141 of the Code of Civil Procedure, the provisions thereof would not apply to the writ proceedings, the phraseology used in section 20C of the Code of Civil Procedure and clause 2 of the article 226 being in perimeteria, the decision of this court rendered on interpretation of section 20C, CPC shall apply to the writ proceedings also. Before proceeding to discuss the matter further, it may be pointed out that the entire bundle of facts pleaded need not constitute a cause of action, as what is necessary to be proved before the petitioner can obtain a degree in the material facts. The expression material fact is also known as an integral fact. Keeping in view the expressions used in clause 2 of article 226 of the Constitution of India, indisputably, even if a small fraction of a cause of action accrues within the jurisdiction of the court will have jurisdiction in the matter. My lord, this was relied upon. Now, my lord will kindly come to para 17, where in a perimeteria facts, my lord, the jurisdiction issue was answered in the affirmative, my lord, para 17, in the facts of this case. We have perused the facts pleaded in the writ petition and documents relied upon by the appellant. Indisputably, the appellant reported sickness on account of various ailments, including difficulty in breathing. He was referred to hospital. Consequently, he was signed off for further medical treatment. Finally, the respondent permanently declared the appellant unfit for sea service due to dilated cardio so-and-so. As a result, Shipping Department of the Government of India issued an order on 12/4/2011, cancelling the registration of the appellant as a seaman. A copy of the letter was sent to the appellant at his native place in Bihar, where he was staying after he was found medically unfit. It further appears that the appellant sent a representation from his home in the state of Bihar to the respondent claiming disability compensation. The said representation was replied by the respondent, which was addressed to him on his home address in Gaya, Bihar, rejecting his claim for disability compensation. It is further evident that when the appellant was signed off and declared medically unfit, he returned back to his home in the district of Gaya, Jorhat, Bihar. And thereafter, he made all claims and filed representation from his home addressed at Goa. And those letters and representations were entertained by the respondents and replied, and a decision on those representations were communicated to him on his home address in Bihar. Admittedly, the appellant was suffering from serious heart muscle disease and breathing problem, which caused him to stay in his native home place, wherefrom he has been making all correspondence with regard to his disability pension. Prima facie, therefore, considering all facts together, a part of the or fraction of the cause of action arose within the jurisdiction of the Patna High Court, where he received the letter of refusal disentitling him from disability compensation. So, my lord, my humble submission is, my lord, what was laid down in Kusum in Gods was relied upon by the Honorable Supreme Court in my lord Nawal Kishore Sharma, where, my lord, when the correspondences were made and replied, and it was said, my lord, a fraction of the cause of action did arise in that jurisdiction of the court.
But
Therefore,
Mr. Chaudhary, in that case,
yes,
the person concerned immediately after being found medically unfit, he has come to Gaya. He was residing there. Thereafter, all the
there he made the
correspondences
correspondence.
were happening between that person concerned and the person concerned and the officials from Delhi. And thereupon, there was a writ petition which was filed. There was no objection at that point of time taken. And thereafter, the payment of an amount of rupees 6,27,000, 2,67,000 was also made on the basis thereof. It was everything was happening. There was no issue as regards cause of action, but the Patna High Court has said that at the time when the matter was finally taken up, there was no cause of action. There was no objection raised at that initial point of
No,
time.
my lord, no. No, question is, my lord, whether in view of the exchange of the
Because what you are submitting has serious consequences. What you are submitting here,
yeah,
because any person may, these are all pan-India tenders.
yes, pan-India tender.
These are pan-India tenders. So pan-India means everybody can participate.
Yes.
Once anybody participates from anybody, so everywhere a person can file a writ petition.
No, my lord,
It will have to take
ONGC is a government of India undertaking, my lord, having its substantial presence in the state of Assam. They have got, my lord, I think that at one point of time, the registered office was in Sibsagar only. Subsequently, only the corporate office was, shifted to, I think, my lord.
Now to register office is not.
Sorry, there are originally.
No, now to register office is not there.
No, the registered office is presently in Delhi, my lord. There is no dispute, but they are having a establishment in the, my lord, state of Assam.
I would have understood this establishment as regards an establishment out here, the tender was issued for a purpose out here, then the question would have been different.
My lord,
But that has nothing to do
no,
out
my
here.
lord, my
Now,
humble
in this
submission,
Nawal Kishore's point, this is as regards payment of a pension amount to him at
my lord,
in his place of residence.
my lord, my humble submission, I hope. Cause of action has arisen partly in Guwahati and only in Gujarat. So this petition
How
would
is
have
it
been filed.
partly?
Because, my lord, I have submitted my tender from here. The communications were made to me from their office to us. I made communications with them. So that's what Supreme Court has said. Because of the exchange of the communications in para 17 of that, my lord, Nawal Kishore Sharma, the Supreme Court referred to in para 17, it says that.
No, Mr. Chaudhary, the Nawal Kishore's case is a case where a person is going to get his pension at Bihar.
My lord, supposing, my lord, tomorrow in an arbitration, in the agreement, there is a clause that in the event of any default, court at Gujarat and court at Assam will have jurisdiction. They can do that.
No, not if in this case, no, because there is no cause of action arises.
But for the communication, there is no. But for the communications, a fraction has arisen.
The communication had to be given to you here because, but we are under decision-making process. Where did the decision-making process happen?
Well, if I have correctly understood paragraph 70, the reason why the Honorable Supreme Court held in favor of that person who was suffering from some difficulty reading and all because he made communicate, he was settled post his dissettlement, he was in Goa, he made communications, he was, replied to, he made further communication. This fact constituted a fraction of the cause of action. I'm relying on that, but for that judgment, my lord,
But where is he going to get the compensation?
my
Tell
lord,
me, where is he going to get the compensation as per Nawal Kishore? If you see paragraph 17, he is going to get it at Bihar,
nowadays they will pay in the bank account.
But-
Nowadays it's not,
but he's going to get the compensation at Bihar, where he is residing. Just for example, I'm a central government employee. The central government employee may have a pension or any claims out
No.
there against the central
my lord,
government.
only point is because of the exchange of communications, whether it can be construed to be a case of fraction of cause of action having arisen within the jurisdiction of the Guwahati. That I'm relying on that, my lord, para 17 of that Nawal Kishore Sharma.
My lord, one
Otherwise,
direct
my
judgment is there, my lord.
I can appreciate, my lord, in a given case where, my lord, there is a dispute of husband and wife. Husband institutes a case in a cut-off place where, my lord, wife is in a disadvantageous position. Mighty ONGC, my lord, why there, had it been a case that not have any establishment in Assam, I could have appreciated.
Is this the judgment ONGC?
My lord,
Where the Supreme Court went to say that if a person crosses from flies over Calcutta,
yes.
the Calcutta High Court will assume
No, Utpal Kumar Basu.
No, it is, yes.
Yeah.
No, my lord, there was a time, I shouldn't say that, my lord. It was said that Calcutta High Court was very liberal in, it is in that context, my lord. Anyway, those are no longer there, my lord. No, my only submission is that, my lord, in the factual background, lordship will have to give a finding on whether a part of the cause of action, which according to us is a fraction of the cause of action, has arisen within the Guwahati High Court jurisdiction. If yes, whether, my lord, we can maintain the writ. I'm reading it once again, my lord, for lordship's kind
Why didn't you
consideration.
go to Gujarat?
My lord,
Why didn't you go to Gujarat? Give you 10 days, you go and file a matter in Gujarat.
then my lord will keep the order for 1 week. I will go.
You go
Yes,
to Gujarat
we'll go.
for 7 days.
7
this
days.
matter
Yes,
will-
we'll go.
So this is not the
Ah.
case. Sir. Because,
7.
because if I dismiss it, it is going to have more consequences. Court is not.
7 days time, my lord, we'll go.
Give 10 days.
10 days.
Though we have a direct flight.
10 days. 10 days. All right.
The interim order will be there for 10 days.
Yes.
And I'm not expressing anything on
Opinion.
merit, except
Lordship will keep it for some future.
I'm not saying anything on merit. I'm saying only the interim order, and the Gujarat High Court shall take a call
Yes.
as to whether the petitioner is entitled to any relief or any interim order.
No. Lordship, if- Okay. Can I fight?
The learned senior counsel. No, the instant petition has been filed challenging the rejection of the technical bid of the petitioner.
They call it techno-commercial.
Techno-commercial bid of the petition. In respect to a tender issued by the G E to M capital for and on behalf of the respondent.
Well, actually, the respondent is not in the picture, my
Or
lord.
ONGC, no?
Oh,
This has been done for ONGC. This has been done for and on behalf of the ONGC.
Yes, but Vadodara is a separate matter region. Yes,
GM does it because you have to make a requisition to
Well-
GM. GM does is it's a government marketplace where
Correct.
they do it.
Well-
So this
Now it
tender
is
is
take
for and on behalf of ONGC
Gujarat assets, my lord.
For
Assam's are Assam. assets.
hiring of services for 3D seismic data acquisition in capital Liberia NMONHP 20201 Narmada area for FS 202223. The petitioner have assailed their said rejection. On the ground, rejection of the techno-commercial bid. On the ground,
Of not meeting the, my lord, requisite net worth criteria.
that the proviso to clause 6 was not taken into consideration. This court, by an order dated 31/5/2023, issued notice and as an interim measure provided that the financial bid in respect of bid number GEM/2022/B/2542603 dated 29/2022 in respect of item category inverted comma custom bid for services desk hiring of services for 3D seismic data acquisition in NMONHP 20201 Narmada area for FS 202223 inverted comma shall not be opened. The respondent, pursuant to the said notice, appeared and filed an affidavit, detailed affidavit in opposition. In the said affidavit in opposition, the territorial jurisdiction of this court to entertain the writ petition has been questioned, which touches on the maintainability of the incident writ petition. Various other aspects also have been mentioned in the said, the case of the petitioner have also been refuted in the affidavit in opposition. To the said affidavit in opposition, a reply has also been filed by the petitioner. When the incident writ petition was taken up for hearing, This court, taking into account the judgment of the Supreme Court in the case of Adani Exports. Where is that? Adani Exports. What is this page number, Nawal Kishore?
Nawal Kishore, my lord.
Adani Exports, yes. Adani, Union of India versus Adani Exports Limited, reported in 2002, 1 SCC 567, had taken up the question of maintainability of the writ petition on the ground of territorial jurisdiction. Upon hearing the matter, the learned senior counsel submitted that the petitioner may be permitted to withdraw the instant writ petition and be given a liberty to approach the Gujarat High Court as the work in which pertain to
Narmada Basin.
into the why the writ petition was not maintainable at Delhi if the ONGC has?
I don't know.
That is the most important thing.
Certainly.
Surprisingly,
From all
the-
angle, defendants reside.
yes, there's no way out.
That's what I was also wondering, my.
My lord, another, my lord, my question is this, my lord, that we undertake, my lord, that for 10 days we shall not do anything. That may be according, my lord, your lord.
Line to follow. Instant writ petition and move the and move an appropriate writ petition. Challenging the rejection of the techno-commercial bid before the Gujarat High Court, taking into consideration that the work that taking into account, consideration that the tender was in respect to hiring of services in the Narmada area, which falls exclusively within the jurisdiction of the Gujarat High Court. The learned senior counsel further submitted that the interim order which has been passed and continued by this court, the interim order dated 31/5/2023, which was passed by this court and had been continued from time to time, be extended for a period of 10 days so that the petitioner may approach the Gujarat High Court. Mr. G.N. Sahewala, the learned senior counsel appearing on behalf of the ONGC, submits that he has no objection as regards the withdrawal of the writ petition and filing and liberty given to the petitioner to approach the Gujarat High Court. He, however, submits that the respondent shall not open the tender and the financial bid for a period of 10 days from today. Taking into account the above, therefore, this court closes the instant writ petition on withdrawal, thereby granting the liberty to the petitioner to approach the Gujarat High Court, challenging the rejection of the techno-commercial bid of the petitioner. Full stop. This court further takes note of the undertaking given by Mr. J.S., the senior counsel appearing on behalf of the respondent. That the said respondent shall not open the financial bid in respect to the tender in question for a period of 10 days from today. With the above, the petition stands. I extend this point.
Yes, my lord, I just-
Secondary law.
And number 12,
और 12 बोला अभी। कुछ किलो कौन मूड लिस्ट कौन मूड लिस्ट को 12 itu kita balik tu hoi gol itu tu dalton dia disebut point. Yes, what is this matter? Odon Bora.
Hello, I'm the petitioner here seeking, there is a respondent number 7 has illegally cut the hill adjacent to my land, my lord. So,
He's doing what?
illegally cutting the hill.
You are cutting.
Lordship, Lordship may kindly have a look at the last order, Lordship.
Yes. What is the order? It has come to the notice of the one of the issues which may arise for termination is that the respondent number 7 is in with regard to the breach of the deed of agreement dated. Therefore, whether the breach of contract can be a subject matter of a repetition shall be assessed by the learned senior. Yes,
Lordship, and this regard, my senior will like to address it.
fantastic. We'll have it summer ready. List the matter after 4 weeks at the request of the petition. Thanks.
Much obliged.
Okay. Untu. Two eyes in it. Has your counterpart come? Yes, there.
That is the Lordship. And the central bank employees pension regulation 1995. There is a clause by that regarding compulsory allowance.
You want that?
Yes, that will. This is the only thing.
Who has been dismissed or removed or terminated shall forfeit his pension provided that the higher authority may competent to dismiss or may but dismissal remove or not and the case is deserving of special consideration. See, you got something.
Yes, ma'am.
So you do one thing.
Right.
You have challenged all these things.
Yes,
You file an application. And I say, you file an application and they shall consider within a period of 2 months. Isn't it?
Madam.
Higher authority is who?
Here, my lord, I think,
Who dismissed him?
yes, ma'am.
this issue,
আগৰ অৰ্ডাৰটোত এটা লাইন লিখি দিব না this court it is clarified that this court had not expressed any opinion on the merits of this.
my lord, this issue,
Regional matter.
this issue, similar to this issue, my lord, the Supreme Court has dealt with, my lord, in another case, which was from the police department. May I place it, my lord, in paragraph 10 and 11, my lord, this has been dealt with. In 1995, it was. Your lordship may kindly see the paragraph number 2 first. Paragraph number 2, issue number 2.
Whether a person who is subject to Army Act can be dismissed from service for committing an offense under the Act, even after he has retired. Yes, then
Then paragraph number 10, ma'am. 10 as well as 11.
we find the draft of pension and gratuity. So this is the same.
Same, my lord. More or less same,
Like
my
of the
lord.
plain
Like-
language. No, that is not the issue here.
No, ma-
I'm also saying
yes.
he's not
yes.
entitled to pension. That is the only issue here. But whether he'll be not entitled, if he's entitled or not, here he said, provided the higher authority than the competent to the may, if such dismissal of so and so, you higher authority let them consider
Yes,
this.
yes, that is there. Ma'am, that thing.
That is for if a person has qualifying service.
Yes,
On the ground that he has been dismissed, can you withdraw his pension or not? That was the issue. And the Supreme Court says that no, because of it is clearly given that you can't. So here also, I am not saying that he's entitled to pension.
Yes.
But I'm only saying about the other thing, the proviso. Where in terms with the proviso, let him apply.
but. As regards my other, the factual parts and the, if lordship, I have prepared some case laws here, if your lordship,
Which one?
regarding this, his entire departmental proceeding and all.
Not necessary. We don't go much into
Yes.
deep into this.
Yes, yes.
Isn't it?
Yes.
Yeah. And let him also get a chance if he wants and file an appeal. Because if he files an appeal, that will go. He won't. And for you, you consider, so you also won't. The matter ends quietus.
Yes.
The instant repetition has been filed by the petitioner, challenging the order dated 22/3/2010 issued by memo number RO/GU/WA/DAD/2009-10/304 issued by the respondent number 4, thereby imposing ultimate punishment of dismissal from service. Thereby imposing punishment of dismissal from service. Where is that document?
My lord, page 68, my lord, section 8, my lord, administrative order. Page 68.
One dismissal, thereby imposing the punishment, the penalty of dismissal which shall ordinarily be a disqualification for future employment. Challenging the order dated so thereby imposing the penalty of dismissal, which shall ordinarily be a disqualification for future employment. Semicolon. For setting aside and quashing the consequential order dated 28/2/2011. Where is that?
Yes, my lord, that is page,
Appellate order.
yes, page 95, my lord.
Order dated 28/2/2011. Whereby the appeal so filed by the petitioner was dismissed. Semicolon. For interfering with the said as well as for a mandamus directing the official respondents to impose minor punishment upon the petitioner as provided under regulation 4 brackets small a, comma, small b, comma, small c, comma, small d, and small e of the Central Bank of India, officer employees bracket discipline and appeal bracket close regulation 1976. The facts of the instant case is that the petitioner initially was appointed as a clerk at Provisional Bank on 8/1/1975. Subsequent thereto, he was promoted to the post of assistant manager at Provisional Bank. The same Provisional Bank thereupon amalgamated with the Central Bank of India, and the petitioner continued to act as the assistant manager at Numuligor branch. The petitioner thereupon was again transferred to Jorhat in the same capacity. The petitioner rendered service for around 12 years at Jorhat and was transferred to the Panbajar Market branch, and from where he was again transferred to Maharipara branch as the branch manager at the BTAD area. Thereupon, the petitioner was again transferred to Kohima as the assistant manager. At the time when the petitioner was serving as the branch, so you were demoted when you went to Kohima. You were demoted. Then how did you become an assistant manager after a branch manager?
Hello, this branch was a very small branch. The designation may be there, but the original designation was assistant branch manager.
While the petitioner was working as the assistant, rendering his service as the assistant manager at Kohima branch, he was issued a charge sheet on dated 16/4/2009. Was issued a notice on 16/4/2009, thereby calling upon the petitioner to show cause as to why departmental proceedings should not be initiated against him for commission of gross misconduct while discharging his official duty at Maharipara branch. The petitioner thereupon submitted his application the said application, the concerned respondent authorities, the disciplinary authority being not satisfied with the said explanation so given by the petitioner, initiated the departmental proceedings and served a charge sheet on 6/9/2009, which contained 4 specific charges. Subsequent thereto, there was an additional, a supplementary charge sheet was also issued on 25/8/2009.
It is 6/6. It is 6/6.
Huh?
I think 6/6.
6/6 or 6/9?
Oh, 6/6.
6/6. 6/6. Yep.
First charge.
6/6 over there. Go on. A second one, 25/8. Had issued a supplementary charge sheet on 25/8/2009, which contained another 3 charges. Remaining, I'm coming back.
আগতে এগোনি এটা হয়ে গেল নাকি কেউ টাইম লেখেন
লিখলে লাগতো। The petitioner, though participated in the said departmental proceeding, but did not submit any statement of defense to either the original charge sheet or even to the supplementary charge sheet. Thereupon, the inquiry was conducted. And the inquiry officer submitted the report dated 27/11/2009 to the inquiring authority, to the respondent number 4 on 30/11/2009. The petitioner thereupon was given the opportunity to submit his report, to submit his reply to the said inquiry report within 7 days. It further appears that the petitioner submitted his reply the disciplinary authority thereupon, taking into account the inquiry report as well as the reply so submitted by the petitioner, passed the order dated 22/3/2010 whereby imposed the penalty upon the petitioner of dismissal, which shall ordinarily be a disqualification for future employment. This order has been put to challenge in the instant writ proceedings. The petitioner, being aggrieved, thereupon preferred an appeal before the appellate authority. The appellate authority, by an order dated 28/2/2011, dismissed the appeal, thereby confirming the penalty so imposed upon the petition. This order, this appellate order dated 28/2/2011 has also been put to challenge in the instant proceedings. It appears from the records that the instant writ petition was filed on 17th of September 2011. And this court, by an order dated 21/9/2011, had issued Rule making it returnable on 16/11/2011. The record further shows that the affidavit in opposition has been filed by the respondent number 2, 3, 4, and 5. Wherein it was stated that the petitioner was given due opportunity for filing the statement of defense to the original charge sheet as well as to the supplementary charge sheet, which the petitioner failed to do in spite of opportunity, in spite of various opportunities being granted. It was further stated that from the evidence on record, it would be clear that the petitioner that the charges against the petitioner have been duly proved. It was further mentioned that as the charges have been duly proved and the petitioner was working in a financial institution and the allegations so proved pertain to misappropriation, the same had occasioned loss of confidence and as such the petitioner was rightly dismissed for service. The petitioner thereupon filed an affidavit in reply refuting to the statements made in the affidavit in opposition. Next. I've heard the learned counsels for the parties and perused the materials on record. This court further proceeding with the instant repetition, with the adjudication of the further prior to proceeding with the adjudication of the dispute, adjudication of the contention so made by the learned counsels for the parties, finds it relevant to take note of. That this court is not exercising an appellate jurisdiction over the authorities. And the limited jurisdiction so exercised is only to consider as to whether the decision-making process is vitiated on account of unreasonableness, arbitrariness, perversity, or have occasioned manifest injustice to the petitioner. The learned counsel appearing on behalf of the petitioner during the course of your hearing could not show any perversity in the findings so arrived at by the inquiry officer as well as by the appellate authority in respect to the charges leveled against the petitioner. Therefore, the question which arises is as to whether the penalty so imposed upon the petitioner was disproportionate to the charges so proved. It is apparent, it appears from the records that out of the 7 charges which were leveled against the petitioner, charge number 1 and 2 related to serious negligence on the part of the appellant in performing his duty as the branch manager. Which was held to be proved by the inquiring authority as well as the first appellate authority. It further reveals that certain employees of the respondent bank misappropriated an amount of rupees 36,89,474. And for that, the respondent bank had suffered pecuniary loss to the tune of the said amount. The charge leveled against the petitioner was on account of his indifferent attitude and negligence. The said employees of the respondent bank would or negligence. The said employees, some employees of the respondent bank would misappropriate the said amount. Which was also held to be proved. Under such circumstances, this court do not find any reason to interfere with the fact finding by the inquiring authority as well as by the appellate authority. Now, taking into consideration that it is on account of the negligence and indifferent attitude of the petitioner, the respondent bank had pecuniary loss to the tune of rupees 36,89,474. This court further is of the opinion that such attitude on the part of the respondent of the petitioner have resulted in the loss of confidence of the employee less of the employee by the respondent number bank. And as such, in the opinion of this court, the imposition of the penalty of dismissal cannot be interfered with. The learned counsel, Mr. A. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the petitioner at present is 72, is 72-year-old. And on account of the dismissal, the pension which he would have been otherwise entitled to have been forfeited in view of Regulation 31 of the Central Bank of India Employees Pension Regulations 1995. He, however, submitted that Regulation 31
For picture is regulation number 22.
No, yes. You may not get shall forfeit his pension. It is given, na?
It is given, but
An employee who is dismissed or year shall forfeit his pension.
that specific provision is at
it's okay.
22.
However, submitted that the taking into account that it was on that the petitioner had not misappropriated any amount, but it was on account of his negligence and indifferent attitude. The respondent, some other employees could misappropriate the amount which had occasioned loss to the respondent bank. The higher authority, the authority higher than the authority than the respondent number 3 ought to have taking into consideration the proviso to Regulation 31(1) of the said regulations of 1995. And ought to have granted a compassionate allowance he, however, submitted that taking into account that the petitioner have challenged the dismissal order as well as the appellate order, the petitioner have not sought for that relief in the instant proceedings. But the interest of justice would be met, taking into account that the instant litigation has been pending from 2011, that an appropriate direction be issued by this court, directing whom?
Above the zonal manager, it is general manager, HRD, Central Office, Mumbai.
General Manager, HRD,
Central Office.
Central Office, Mumbai. Who is the authority higher than the
Zonal.
respondent number 4?
This is general manager. Respondent number 3. Respondent number 3. The appellate
Now, who has dismissed you?
Yes, the regional manager, respondent number 4. And the appellate authority is
Who has dismissed you?
the regional manager.
Above him, who is who?
Zonal manager. Zonal manager is the appellate authority.
You see, here is provided the authority higher than the authority competent to dismiss.
The appellate authority has passed this appeal order. They have to, yes, so I have.
Who is the authority higher than the respondent number 3 and 4? Clear line two.
This is managing director matter. Central Bank.
In that regard. HRD Mumbai.
Yes. HRD Mumbai.
HRD Mumbai. Who is the authority higher than the respondent number 3 and 4? To take a decision as regards the petitioner's entitlement for the compassionate and allowance in terms with regulation 31 of the regulations of 1995. This court have given due consideration to the said submission and is of the opinion that the interest of justice would be met. Have given due consideration to the said aspect, said submission. The record further reveals that the respondent authorities have not taken any decision in terms with regulation 31 of the regulations of 1995. Taking into account the above, this court therefore disposes of the directs the general manager so and so. Therefore, this court therefore disposes of the taking into account the above. This court grants liberty to the petitioner to submit a representation to the general manager.
General Manager, HRD, Central Office, Mumbai.
Thereby, to the petitioner to submit a representation to the general manager, claiming the compassionate allowance on the existing facts. Allowance. This court directs the general manager so and so. Upon receipt of such representation, to take the decision as regards the petitioner's entitlement for the compassionate allowance within 45 days therefrom. The said authority further shall also take note of that there is no that nothing has been proved against the petitioner, that he misappropriated any amount, and it is on account of, and it is only on account of the petitioner's negligence or indifferent attitude. Some other employees would misappropriate the amount as alleged. With the above, the instant petition stands disposed. Mr. Chaudhary, that is the only.
Yes. It is
Or
only
you have not thought
Yes.
of anything.
Yes. Because of your lordship, point.
Huh?
Your lordship insisted me to find out this thing.
Yeah,
Yes,
this only help.
yes.
Okay, next.
Item number
Oh, my-
14. 14.
Lordship, I've taken an instruction.
Oh, that matter,
Yes.
yes.
They have not withdrawn that notice, Your Lordship.
Then what are you going to do?
Lordship, since the period is already over, 5 years is already elapsed, Your Lordship. The tender validity was for 5 years. It was
So means-
2017. So it's already elapsed, Your Lordship.
Now, the petitioner initially there was a tender.
There was a tender, yes.
In that tender, the petitioner was number one.
He was selected, but he was never given the settlement.
Okay, he was not given it. Then you cancelled it.
We cancelled it
For why? What reason?
because the query, which was inside the reserve forest, there are certain conditions laid on the central government
But that is, have you mentioned it in your affidavit?
that we have not mentioned.
Then tell me the reason why have you cancelled it?
Because the reasons we have not stated, even we don't have the notification issued by that.
I am not on that. What is your reason in your affidavit?
Reasons.
The reason is different, my lords. Reason they have cited in their affidavit that the VFO has no power to call NIT beyond the value of rupees 25,000. That was the.
Where is it?
My lord, their affidavit, my lord, page,
Para?
there is a long paragraph.
Para 7, Your Lordship.
It starts from affidavit page 4. Last
Page 4.
mile.
Now, where are you saying that a short tender notice for sale of Iman was granted for grant of naming contract? Various reasons. The serial number 4 of the tender notice is show me the Assam minor mineral concession rules. Yes, give that. On full credit. We are concerned with Borjang,
Bajrang,
stone quarry.
my lord.
Government value is 5,16,000. Who has issued this? Tender?
DFO.
Huh?
DFO. Rule 23 says, Your Lordship.
Who is the person who is competent to accept the bid
The competent authority is the
as per the delegation of financial rules 1999?
is the PCC, Your Lordship. The definition of competent authority is given at definition clause number E, Your Lordship,
Of
of the Assam Iron Mill Concession Rules, clause E,
clause E.
2E, Your Lordship. It's a competent authority.
E. Means the director of geology and so and so. No. Competent officer competent to accept bid tender in accordance with the provisions of the delegation of financial rules 99. Who is the person who is authorized? Don't know anything. What are you making, Mr. Gogoi?
Yes, Your Lordship.
Yes, you have not prepared.
Lordship, here the matter is that since first tender, which the departments floated, the floating of tender was cancelled. Thereafter, second tender was issued. Thereafter, stay was obtained from this court. We didn't proceed with that second tender also. And that tender was for a period of 5 years. That's already lapsed, Your Lordship. And now the issue is that no mining query can be leased out, which has the quantity of less than 5 hectare, Your Lordship. And in both cases,
Where is that document?
yes, sir, I have that.
Show me that. 9,000 yo. Because your affidavit is completely different from what you are saying.
Yes, sir, Lordship.
You are supporting him. You say that he has a legitimate expectation. Haven't you? That's-
We are supporting. We are.
What is the minimum size here? In Borjang, as per the notice inviting tender. First of all, it is why on earth have you issued a short tender notice? Tell me. On the face of it, it shows some illegality.
Yes, sir.
You couldn't have issued a short tender for 5 years.
Yes,
There's no urgency out there. There's something very wrong on the face of it. That is why the court had stayed it. But I'm asking you, what is the area out here? You are saying the
First,
minimum size of the mine lease should be 5 hectares.
5 hectares. Sir.
Now, are you saying that Bozrong stone quarry is not 5 hectares?
Bajrang stone quarry is, Your Lordship. Its quantity is given as 2,000 meter cube, Your Lordship.
Then
And in that issue, I have another notification, Lordship.
So as per this, now it cannot be less than 10,000.
Yes, sir. Cannot be less than 10,000.
So both the tender has to be gone.
Yes, sir.
This makes sense. Now, who is as per the delegation of authority? Who is he? Mr. Day, were you at any point of time given any order that you have been selected?
No.
Huh?
No.
And what is your right? Having a comparative statement, what is your name?
My lord,
Anil Chandra Pathak. Who is he?
my lord, he is in respect of the Bajrang stone query.
Are we concerned with Sivakunda or
Sivakunda also. Both.
Sivakunda.
Sivakunda or Bajrang?
Sivakunda and
Bajrang, both.
the two petitions.
You participated in both.
Both.
One with petition.
No. Two petitioners are here, my people.
Oh, okay. Who are the two petitioners later? And both the petitioners are different. Different for different queries.
Different query.
Wow. Now, Mr. Day, how about imposing costs? Cost has to be imposed. How is it possible, Mr. Day? Is it possible? Two contracts, two persons, everything is different.
Same NIT, my lord.
So, same NIT. RD Enterprise, yes. TM is 20,000, bid offer is 205 per metric, regular, irregular. So yours is 205. Here, somebody else has given 202. And what is the other one? The other? This is Sivakunda. What is about the other one?
Other one, Bajrang stone.
Huh?
Bajrang stone.
Oh yeah, divisional forest officers so this is file in the 209. Please file and post the photocopy of the prayer petition along with documents received from the Sivakunda, RT Enterprise, Bogora, 12. You are requested to submit the above mentioned Mohol details, including current status of the Mohol document. Huh? Where is it?
My lord, item number 5 is the Bajrang stone.
Item number 5 is where?
NIT page 13.
No. Any similar document like what is there at page 20? This is Sivakunda. What about Bajrang?
My lord, no such document.
No such document.
So you have only as regards Sivakunda. Huh?
Sivakunda.
Where is the delegation of power rule? Delegation of Financial Power Rules 99. You have it? The Google is sad.
Lordship, I don't have the tool right now with me, Lordship. Okay.
The forest department is in shambles. This is the manner in which you do a matter. I would have understood the matter coming out all of a sudden. You don't know. But this matter has been going on for the last 4 days, isn't it?
Yes, Lord.
Then Anybody from the finance department? Hello. The two petitioners hearing have approached this court challenging the issuance of a fresh short tender notice for grant of mining contract to collect minerals of Bajrang and Sivakunda stone mall in Dharamtul West Range of Nagaon Division, invited by the Principal Chief Conservator of Forest, Guwahati. It is the case of the petitioners herein that the petitioner number one participated. The petitioners herein, it is the case of the petitioners herein, that they had participated in pursuance to a notice inviting tender dated 7/2/2014 in respect to Borjong, BARJANG stone quarry area and Sivakunda stone quarry area. It is relevant to take note of that from a perusal of the notice inviting quotation dated 7/2/2014, it appears that the Bosrong stone quarry area, for the Bosrong stone quarry area, the total quantity per annum was 2,000 meter cube with a reserve price of 258 per meter cube and the gross value was rupees 5,16,000. In respect to Sivakunda stone quarry area, the quantity was 2,000 meter cube per annum, with a reserve price of 252 per meter cube, and the government value was rupees 3,04,000. The petitioner claims that they had participated in the said tender proceedings the petitioner number one, it is the case of the petition that the petitioner number one was the highest bidder in respect to Borjong stone quarry, whereas the petitioner number two was the highest bidder in respect to Sivakunda stone quarry. It is, however, not apparent as to whether the petitioner number one was the highest bidder in respect to the Borjong stone quarry, as there has been no documents enclosed. But in respect to Sivakunda stone quarry, it appears from Annexure 6 that the petitioner number two was the highest bidder, but the bid offered by the petitioner number two was less than the reserve price. Be that as it may, the petitioners herein were expecting that they would be settled the said queries when a short tender notice for sale of minor minerals was issued by the principal chief conservator of forest and head of forest force, Assam, on, well, what is the date? That date is also not there.
The second one is 15/3/2017.
Huh? No, that, yes. What is the date of calling for the tender? Fresh tender?
7/2/2014, first one. And second one is 15/3/2017.
On 15/3/2017. It is under such circumstances that the petitioner has therefore approached this court challenging the said tender proceedings, tender notice. The said tender notice have been enclosed as Annexure 10 to the writ petition. And from the said tender notice, it reveals that the said tender was called for a period of
5 years.
5 years. The respondent number 3, that is the Divisional Forest Officer, Nagaur Division, had filed an affidavit in opposition In the said affidavit in opposition, a reference was drawn to a letter number B oblique stone query area oblique 2014 oblique 1460 dated 4/3/2014, issued by the Member Secretary, State Environment Impact Assessment Authority, Assam, by the then Divisional Forest Officer, Nagaon Division, Nagaon, for according environmental clearance in respect of Sivakunda Stone Quarry under Kolahat Reserve Forest, wherein it clearly mentioned that the said letter is neither a letter of intent nor a settlement order. It was further mentioned that only after obtaining the Minister of Environment and Forest final approval as per Section 2 of the Forest Conservation Act 1980 from the Regional Office of the Ministry of Environmental Forest, Shillong, the area would be allowed for settlement after the issuance of a LOI from the higher authority. It was therefore submitted that the petitioner's bid was the petitioner number 2's bid in respect to Sivakunda Stone Quarry having not been accepted by the higher authority, the entire and a letter of intent having not been issued, the entire case of the petitioner is baseless. It was further mentioned that though the notice inviting quotation was issued on 7/2/2014, but the Divisional Forest Officer, by the Divisional Forest Officer Nagaon, but the said authority was not the competent authority pertaining to minor minerals by government notification number FRM.300/2012/321 dated 17/5/2013. To accept bid oblique rates of an amount more than 25,000 under the provision of the Delegation of Financial Power Rules 1999. It is under such circumstances, the received quotations were forwarded to the higher official authorities for necessary acceptance of the bids oblique rates. However, the same was returned back by the Office of the Principal Chief Conservator of Forest and Head of Forest Force through the Additional Principal Chief Conservator of Forest (T) Upper Assam Zone by the letter dated 15/10/2014 for taking necessary action as per rule. The Divisional Forest Officer Nagaon Division mentioned that in his letter that as there was no clear-cut rules regarding settlement of minor mineral mohols with the RF within the RF areas under the Assam Minor Mineral, what is it? Minor Mineral?
Some minor mineral concession rules.
Concession Rules 2013 and Section 2 of the Forest Conservation Act 1980, which prohibits tender sale of mohols under the RF area. the divisional forest officer, Nagaon division, had to cancel the whole quotation by an office order number 5 oblique dated 2/1/2015 and communicated to all concerned by a memo dated 2/1/2015 as well as it was further mentioned that all the quotationers were also informed by another memo dated 2/1/2015 to collect their earnest money draft from the office of the divisional forest officer, Nagaon division. It was further mentioned that the said submission, that it was further mentioned that the then divisional forest officer Nagaon forwarded to the additional PCCF bracket P, comma UQAZ by the conservator of forest NAC Tejpur by the communication dated 9/3/2016. It further reveals from the records that an affidavit in reply was filed by the petitioner, wherein it has been mentioned that the cancellation of the notice inviting quotation dated 7/2/2014, while the order dated, office order dated 2/1/2015, was not communicated to the petitioner. And as such, the petitioner had no knowledge about the same. It was further mentioned that the statements made in the affidavit in opposition by the respondent number 3 about the office order number 5 dated 2/1/2015 was an afterthought, void document prepared with a view to give undue advantage to a third party. Mr. Day, what is this document at page 62? Page 62 of your reply, which is Annex 12.
But subsequently, we could collect.
So you got this document.
Now, at the time of filing of this reply, ma'am.
Understood, you got it. So this document clearly shows that it has been cancelled on 2/1/2015. You have not challenged this. Then be it as it may, it is however relevant to take note of that the petitioners themselves have enclosed the office order number 5/5 dated 2/1/2015 as annexure 12 to the affidavit in reply, which clearly showed that the tender, that the notice inviting quotation dated 7/2/2014 and the corrigendum notice dated 20/2/2014 was cancelled due to technical difficulties, and the bidders were requested to collect the earnest money which was submitted along with the quotation on 28/2/2014. Next. I've heard the learned counsels for the parties. Mr. R.R. Gogoi, appearing on behalf of the Forest Department, submits that the notice inviting quotation dated 7/2/2014 had to be cancelled in view of the reasons which have been duly mentioned in the affidavit in opposition filed by the respondent number 3 in paragraph number 7. Relevant herein is to note that the said aspect of the matter has already been duly taken note of in paragraph in the previous segments of the instant judgment. The learned counsel further submits that on account of the above, that the divisional forest officer had himself cancelled the said notice inviting tender quotation on 2/1/2015 and had asked all the concerned bidders to collect their earnest money. Subsequent thereto, the learning counsel further submitted that subsequent thereto, the competent authority, that is the principal chief conservator of forest, had issued the impugned notice inviting tender. Short notice, tender notice for sale of the minor minerals on on so and so 10 ki baat aati. What is the date?
The date is 15/3. 17.
16/3/2015.
15.
15/3/2017.
17.
The learned counsel, however, submits that the said short notice, tender notice for sale of the minor minerals which have been impugned have also been rendered infructuous now, taking into account the period of 5 years have elapsed, and further that the Forest Department has to take the permission from
the Ministry of Environment and Forest, Your Lordship.
Ministry of Environment Forest prior to for conversion of the
Reserve Forest.
reserve forest into
into non-forest activity, Your Lordship.
Non-forest activity. He therefore submits that the same short tender notice for sale of minor mineral cannot be acted upon now by the forest officers, forest department without the said permission. I'm coming here. From the above, submissions so made by the learned counsel for the forest department and taking into account that the quarries, stone quarries in question are in the reserve forest area, and there is no approval yet given by the Ministry of Environment and Forest for conversion of the reserve forest area for what is that?
Forest activity.
For non-forest activities. It is the opinion of this court that both the notice inviting quotation dated 7/12/2014, 7/2/2014, as well as the notice inviting short notice, tender notice for sale of minor minerals issued by the principal chief conservator of forest and head forest dated 15/3/2017, are not permissible. In that view of the matter, the notice inviting quotation dated 7/2/2014, as well as the short notice tender notice for sale of minor minerals dated 15/3/2017 cannot be acted upon. In view of the approval not received from the Ministry of Environment and Forest. Under such circumstances, there is no enforceable right which has accrued upon the petitioners on the basis of being the highest tender in respect of a notice inviting quotation, which is otherwise not permissible under law. Accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Interim orders, if any, stands.
For orders, item 3 and 4.
I appear with Mr. Pritam Baruwa.
Hmm?
I appear with Mr. Pritam Baruwa for petition.
With whom?
Pritam Baruwa.
So
Yes.
you
Lordship, in
submit.
this matter, we have filed 2 IAs, your lordship, on the maintainability of the petition. So if those IAs are taken up first, your lordship, perhaps.
Okay, what is the ground?
The ground, your lordship, in a nutshell is, first ground is that it's a purely contractual dispute between the parties. They are against the encashment of a bank guarantee. Secondly,
Encashment of a bank.
bank guarantee. Secondly, there is a alternative
Main
ramifications.
petition. Kindly give this to your friend, Mr. R.R. Book.
The second ground is, your lordship, there is an efficacious alternative remedy in the petition, your lordship.
This is by which one you are repairing? Power.
In both writ petition, 57 and 5669.
What are these two petitions for?
Lordship, these are the writ petition whereby the state instrumentary respondent has invoked my bank guarantee, performance bank guarantee. I have sought refund of it because according to me, that's the arbitrary unreasonable action. I am supported by the judgment of this honorable court, confirmed by the division bench. Similarly situated contractor whose bid guarantee was invoked by same respondent. Writ petitions were filed, learned single judge allowed. Mandamus was issued to refund the security bid security deposit. Division bench confirmed that order.
Was your contract terminated?
Lordship.
Then what happened? Show
Lordship.
me the terms and conditions of the bid
Lordship.
agreement.
Bid, first of all, my lord may turn to page 21. There is a notice inviting bid. That's the initial document whereby respondent invited bids for electrification of areas of various districts of Assam. This is a founding document, and pursuant to this, I was subscriber to the bids, and contract was awarded to me. The contract is on page.
Okay, then
Thereafter, lordship, there was an unrealistic time frame given to us that we have to complete the rural household in 3 months. Be that as it may, I went on doing the project after the cutoff date. They thereafter issued the notice. On 6/2/2000, they issued so-called. I gave reply. They did not buy my reply. They terminated the contract. I have till then no issue. I am not challenging even that aspect. 4 months after termination of the contract, one fine day they invoke my performance bank guarantee. Now that action, according to me, is plainly impermissible in law because it's the state instrumentary. It is governed by the rules of reasonableness, which are not applicable to private, but it is applicable to it because it's the state instrument.
let us see the terms of when can it be invoked.
Lordship. That performance bank guarantee, my lord will find.
Now, where the bank guarantee can be invoked when you must
that
have given
contract
it.
is absolutely silent, but page 33, Lordship. First,
That is guaranteed 3 Axis Bank so and so. Why have you given this bank guarantee?
I had to give this bank guarantee, performance bank guarantee pursuant to award of contract. Lordship may first come with
Show me the termination clause.
Lordship. Can I show page 33 first?
No, no, first show me the termination clause.
Termination clause. In fact, that is also not there in the.
Is there in the IA.
Lordship, it is in that's what I am saying. Our relationships are bound by the bid document and the contract that we have done. What my learned friend referred is some other document which is not part of the agreement between us.
Show me the termination clause.
Lordship, the contract doesn't mention that
There's no termination clause.
Page 55 to 66, Lordship. That's the contract.
Page.
Page 55 to 66.
Where's the GCC?
Lordship, CCC is not part of the invitation to bid as well as the.
GCC, where is it?
This is the copy.
It's here.
It is not, it is relevant portions are there, but I got the entire thing here because it was voluminous.
Where is the condition? Clause 21.2.
What my learned friend would be relying is on 36.2.1.
Not on that. I'm on it. Tell me. You are saying this is not a part of it. Kindly see page 64. Clause 16.1. 16.1.
If you fail to perform work under the contract within time specified perform in the LOA with respect to successful completion of testing commission, then you shall have to pay APC sum equivalent to 0.5% of the contract price as liquidated damages plus applicable GST. Then earlier week of the delay on the part thereof. However, the total amount of liquidated damages for delay on contract shall be limited to maximum of 5% or total contract plus applicable GST thereon in accordance with clause 21.2 of GCC volume 1 so and so so and so. So Lordship, in case I default on a completion, then liquidated damages in terms of clause 21.2 will be affected. What my learned friend now realized in this IA Lordship, he is relied on clause 36.2.1 of GCC. Lordship,
Mr. Counsel,
Lordship,
where is your agreement?
my agreement is on page 50,
Page
page 55.
50?
But Lordship, if
No, wait.
That is the letter of award.
Wait. Where? Where's your agreement?
Lordship, that's the award.
No, where's your agreement? You have to enter into an agreement. Where's the agreement?
The agreement is in the IA, your lordship.
It
is at page number 36 of the IA.
Page number 36 of the I. Yes.
Sort. Then on page 37.
Finally come to page 38.
30.
So,
Section
DCC is
5.
there.
Lordship, DCC is there. Even this termination is not echo. That is where I
You have not
was-
challenged the termination.
No, I am not challenging termination at all, Lordship. What I am saying is that 36.2.1 envisages that for continuous 3 months, if I fail to do it, then they can do it. Now, allow me to elaborate facts, Lordship. The
Now, why
fact-
you are saying that 36 is not applicable?
Because 3 months have not passed.
Oh, that
or-
is a different thing. That the
Before-
term of the condition is not applicable is a different aspect of the matter from saying that DCC won't be applicable.
Lordship, I am on some different task.
What
I
are
am
you
saying
on?
is that performance bank guarantee that was taken from me, that they could have engaged if there was a defect in my workmanship, if there was a defect in the work that I have executed. Here is a case that without any citing any reason, one good fine day after 4 months of termination, they just invoke it. Now that is where my case is that it's a state instrumentality which is just because they have my performance security. It doesn't entitle them to invoke at the women cap price.
Why not? There is
Lordship,
if they have terminated out there, and do you have anything out there, go under section the section 11 before the Arbitration and
But Lordship,
Conciliation
that-
Act. Why should this court at all entertain such disputes?
Lordship, why? The reason is that it's a state. It is governed by some norm of propriety, Lordship, which are not applicable to private party, but it is certainly applicable to state instrumentality, Lordship. And that is what I was saying. Allow me to narrate.
Mr. Counsel, you have with open eyes entered into an agreement, arbitration agreement.
I have, Lordship, but I am not on the merit of the dispute whether.
I am not on the merit of the
dispute.
dispute. I am also saying with open eyes you have entered that there is an arbitration clause.
Now,
Why should this court interfere under 226?
Lordship, not only Lordship, single job, this court has a contractor similarly situated who was awarded similar tender on the analogous fact. Learned single judge not only allowed the repetition, division bench confirmed that order, and same arguments were advanced by the other side against the same respondent. So if this is the judgment of Writ Appeal Court, and this is Learned single judge's judgment as well as the Writ Appeal.
Which is a judgment. I had appeared in that matter, your lordship. So I am actually it's slightly different.
That's what I'm saying. A same award, if now Lordship allow me to narrate the fact. This contractor was awarded similar contract on 12/11, the day on which I was awarded. His bid security was forfeited for a flimsy ground that we will not, LOA was changed unilaterally by the respondent. This court not only issued mandamus to refund the
amount invoked, writ appeal court confirm that order.
Here the court has gone into the merits.
No, lordship. Again, not
Yes.
for, they have gone on the propriety of the action taken by the state instrumentality. Lordship.
Understood. But the court has gone into the question of merits.
Can I, if, before adverting to this judgment, can
Ah.
I first narrate facts of my matter, lordship?
Yes, tell me.
Lordship, on 12/11/2021,
Hmm.
respondent awarded me contract for Dibrugarh district and Sivsagar district for the electrification under central government scheme.
Yes.
Then on 17/11, I have acceded to their letter of award.
Hmm.
I was to complete contract by 31st of December.
Hmm.
That was completely unrealistic, but I did it. With open eyes, I entered into contract.
Hmm.
On 18th of January, Lordship may mark this day. 18th of January, first time they wrote, second time they wrote that there is a delay in completion, but they don't find any problem with me. On 18th of January, I am working on the ground and they are allowing me to work. On 6th of February, they issue me proposed notice that you are lagging with the performance. Next day, I give them reply. Before that, also I have given them reply. Next day, I give reply to the proposed notice. A week thereafter, on 13/2, they say we are terminating the contract. I even keep mum on this. I don't challenge that decision. But what happens 4 months thereafter, on 9/6/22, they invoke performance bank guarantee.
Hmm.
And combined together in both matters, that is around 50 lakh rupees. Now, Lordship, my case is on page 33. If your Lord can turn with me. Performance bank guarantee is purely for the performance of the work that I have given.
Hmm.
Can I take my Lordship?
Just 1 minute. Why was this petition filed?
Lordship, now I will give
The
facts of those.
Facts of that petition, your lordship, was that APDCL had initiated a tender process where the work completion date was 31/12 of that particular year. The payment was to be made in 3 stages. That was clearly highlighted in the tender document. Now people participated, or lots of parties participated in the tender process, thinking that this will be the payment terms. But when the letter of award was issued, in that case, probably in their case as well, the payment terms were changed.
Huh?
The payment terms were changed. So
Unilateral.
that party instantly said that these payment terms are not acceptable to us. Because you have unilaterally changed the payment terms from what
Oh,
was-
yes. I remember I read this judgment. There he changed the terms, and then also the APDCL authority tried to enforce out there and
Yes.
say that you have to, otherwise we are going to
Yes.
invoke the bank guarantee. And this is how it is.
Yes, we
Terminated.
terminated and
They
encashed the bank
terminated
guarantee.
and they
The
invoke the bank.
termination, that is done under this particular provision of your tender. I'll show you here. This is done under this provision. Where is this? If you don't enter into an agreement, this is the term.
Yes. Lordship.
Ah,
Clause 6, Lordship.
yeah,
Clause 6.
yeah.
But Lordship,
Event of
there
payment.
they invoke the bid security.
So this is the bid guarantee.
They invoke bid guarantee.
And this is the different thing.
This
This
is
is
a
a case of
performance-
termination.
This
That
is a
what I am
performance security.
saying. That is what I am saying, that my case is.
How is the
analogous,
fact
sir.
similar?
I have not said identical fact. I have said similar fact.
How can it be similar?
Sir, that the bid security.
No, Mr. Counsel, I remember these facts. I've read this judgment earlier. This judgment said that there was this particular term out there where there were certain terms which were mentioned on the basis of which he had submitted his tender, agreeing to these terms. The APDCL thereupon changed certain terms for which these person concerned said that no, I am not agreeable to do that. And under such circumstances, the APDCL wanted to enforce the bid guarantee.
Yes.
And for which this challenge was made.
No.
Yes.
Slight correction in the last later portion. They terminated and thereafter they invoke the bid security.
And also the termination has to be done because they have been awarded. Now they have changed the terms and conditions which they are not
Lordship,
accepting.
That is what I am saying. It's a plain arbitrary exercise of the power by the state instrument. When we enter into contract with the state instrumentary, they have disproportionate bargaining power. And
Now you see, kindly see, there the termination was also at stake.
No, Lordship.
There,
No,
the
Lordship.
first challenge in the writ petition was to both the termination as well as they had an interim prayer that bank guarantee should not be encashed. But since no interim directions were passed, during the pendency of the writ petition, the bank guarantees were encashed by EPDCL, but later on, the orders.
But Lordship,
But here
termination
you are
was-
not challenging the termination. You say, yes, termination is okay.
But Lordship, what I am saying is that performance security was taken from me for the work that I have to carry out. There is no fault yet found from me that the work I have done is a faulty. There is not a
But
single complaint
Is
conveyed
this
to
court
me.
going to look into those aspects when there is no challenge to the termination?
Sir, termination brings end to our relationship. He invoked bank guarantee 4 months thereafter, Lordship.
Is it
That
not permissible as per the contract?
Lordship, that is plainly arbitrary. It violates Article.
Is it
40.
not permissible as per the contract?
No, Lordship.
Show me.
36.2.1, which my learned friend realized.
2.1.
36.2.1, page
Okay.
19 of the IA.
Yes.
D. May I read, Lordship? If the contractor fails to achieve mutually agreed deadline as set out in mutually agreed project execution plan per chart for consecutive 3 months, employer shall issue contract termination notice giving suitable time to contractor, which may be up to time agreed between employer and contractor. In case contractor does not improve the performance as per contract termination notice, which shall be within overall plan under mutually agreed project execution plan, employer shall terminate the contract and encase the performance security. Now, Lordship, this is not happened in my case. Lordship, this envisages that he has to. give me 3
Mr.
months.
Counsel, unless you challenge the termination, how can I help you with the second part of it?
But Lordship, just because they have my performance security and just because they have right under contract, it's a they have to see whether I have breached this court or not. Otherwise, Lordship,
Mr. Counsel, they have done under 36 to 1D. To 1D, they say that they have
that is maximum there.
36 to 1D, they have done it. They have done it. They say that we have done it under this thing. This aspect of termination is not on challenge.
Termination is not what I am saying.
If it is
Invocation
not
also
on
part of
challenge,
it.
how can I stop them from encashing the
This
bank
clause
guarantee?
talks about both termination and invocation. This clause does not only speak about termination, and it neither says that invocation will be following the termination. It is two independent things incorporated in D. And what I am saying is that also they have something state instrumentally has of mind with them as a contractor. It does not allow them to appropriate that unless that condition is and if they do it, default that, then I can certainly knock the doors of writ court lordship. That is what the Airport Authority of India since 78 says, and that is what the latest judgment. In fact, the division bench, the contention which my learned friend has taken here, that it's a contractual arbitration clause, everything is taken care of not only by single judge in the judgment I have cited, but the division bench. And division bench says that we are on the impropriety of the action which is taken by the other side. I am on a very narrow compass, Lord. I am not on the aspect of whether they ought to have or they could have terminated my contract. That could be well. And this is plainly afterthought.
Are you saying that they having terminated for your incompetence, which they have done it? You are not challenging.
Lordship, that does not mean that I am incompetent.
No. They have
The-
done it on the basis that you are incompetent to complete. You have not challenged that aspect
But
of the matter.
Lordship, everything I need not challenge. I may not have wherewithal to challenge also. I may not be physically viable. I am a business person, Lordship. If it is not physically, economically viable, I may not change. But that does not mean that I should be saddled with the adjective that I am an incompetent person. What I am saying is that here is a company. I have done work. They found that my work is not as per the, they terminated. Now, if there was a problem with
No, Mr. Counsel, forget about these things. Let us assume not. Can they not recover that amount which they want?
Lordship, but there has to be fault with me.
No. Forget about
There
it.
has to.
Can they not recover for
Sir.
termination?
I am obliged, Lordship. That is precisely my ground in the writ petition. That this is uneducated laws that they are trying to recover from me. And if this is not known in Indian jurisdiction, that a party can recover unadjudicated laws from other party without, and it's the state instrumentality which is doing this. They have my performance security. They consider X, Y, Z as their loss, and they invoke. They have to invoke the arbitration. They can have it losses adjudicated, and then they can recover from my performance. But plainly that they are having my performance security, that they cannot encash it. Lord. That is precisely my case in the writ petition. It's an unadjudicated loss. And Lordship, again I am stressing 13/2/2022 they terminated.
Now, your prayer is for setting aside the invocation and refund the amount. So
Lord,
you have recovered.
they have
Bank guarantee has
after
been,
4 months.
bank guarantee has been encashed. That amount is with us.
Then what is the interim order?
There is no interim. No, we have filed the IA, your lordship,
Challenging the maintenance.
challenging the maintainability of the.
And Lordship may allow to read division bench judgment from para 17 onwards, Lordship. That maintainability aspect is
Yes.
completely dealt with by this code, para 17 onwards, Lord. May I read, Lord?
Hmm.
In fact, 15 onward, page 21, Lord. May I read? Same argument which my learned friend is canvassing in IA, they are dealt with by division bench. Learned, shall I read, Lord? Internal page 21.
Yes, tell me.
Learned counsel for the parties have been extensively heard. Pleadings on record have been perused. Judgment of the apex or relied on by the learned counsel in support of their content have been duly noted. Learned single judge has elaborately dealt with the terms and condition of IFP, that is invitation for bid, as well as the contention raised by the contesting party. Before us, an additional affidavit was permitted to be filed by appellant to bring on record terms and conditions which were enclosed in letter of acceptance dated so and so. Perusal of the terms and conditions in the LOA brought on the record by the additional affidavit vis-a-vis the terms and conditions as specified in IFP make it abundantly clear that there was indeed a change of terms and condition by appellant to the terms and conditions which were earlier published in IFP. The altered terms and conditions were brought to the notice of respondent for the first time only when the letter of award was issued. It is not disputed that
Kindly come to paragraph 21.
20.
21.
May I read 20?
21. I read it.
In view of discussion about judgment relied on by appellant need not be referred to in as much as there is no quarrel with the proposition that contractual matter scope of judicial review is very limited. However, where there is arbitrariness and more particularly when the state or its instrument is one of the parties to the contract, the power of judicial review under 226 of Constitution cannot be excluded. The termination of work order as have been done by the appellant by altering terms of condition while issuing the LOA to the respondent must be held to be arbitrary.
So it is on the challenge to termination.
No, Lordship. Lordship, then allow me to read the facts of the case because termination was never challenged. It was the invocation of the bid security and the refund of it. That was the only question. And that is the only relief that the appellant original petitioner of that matter has got. His was the bid security, mine is the performance security.
Leho. I cannot like it. We'll hear this matter some other day. Why should I dispose of the matter so soon? This matter is not so urgent. I cannot like heard so and so. The instant interlocutory application has been filed challenging the maintainability of the writ petition on the ground of the existence of an alternative remedy. The said aspect of the matter shall be duly taken note of during the hearing of the writ petition. To list the matter for accordingly, the interlocutory applications that the contention so raised in the interlocutory application shall form a part of the pleadings of the respondents. Accordingly, the IA stands disposed. This the matter. In view of list the matter, you have filed your affidavits.
No, we are.
You are filing affidavit.
We were relying on the IA a lot. Or we can bring the same contentions on record if you're not correct. If your
If
lordship
you
directs
don't
us-
do it, you are at trouble. Huh?
Yes, I understand your lordship.
Because
That is why we were relying on
The
the.
learned counsel appearing on behalf of the petition league. The learned counsel appearing on behalf of the PTCL has submitted that without prejudice to its claims, prejudice to its rights, a prejudice to its contentions as regards the maintainability of the writ petition in view of the existence of an alternative remedy, the petitioner the respondents may be permitted to file their affidavit in opposition on merits. 4 weeks time is granted in that regard. The affidavits be filed in the meantime.
I may be allowed to file rejection.
Let him file. ID control. Yes, Mr. Kaur. What are you doing here? A PG council.
They're not very lucky, have to wait all day.
What is the item number?
The item number 5, my lord, that AIDC company secretary matter.
That has been some adjournment. Somebody is asking for some
No,
adjournment.
their requisition was short for in the morning to bring their affidavit in
You
reply.
got it?
Yeah.
Yes, what is these new things which have been brought?
My lord, your lordship will kindly recall the last query made out by the order dated 33/2023 in the writ petition, my lord. 2 queries were made.
Whether the AIDC was bound in terms with the memorandum of understanding entered into with the government of Assam even prior to its whether putting the period
I think I'll briefly rephrase the matter.
yes,
Well, the petitioner, who is a lady, was appointed as a company secretary on 17/6/1995 in AIDC. My lord, her last promotion was 31/12/2002 as company secretary. From 2002, after next 10 years, she is eligible to the next higher scale of pay in terms of a scheme called SLASH, Service Link Advancement Scheme. Well, this scheme came into force on 21st of September 2001. In terms of the scheme, my lord, if I complete 10 years of service, then I'm entitled to the next higher grade scale of pay. Because otherwise it will bring, the whole object of the slash was that to remove stagnation in service. Otherwise it will demotivate the employees to work efficiently. In 2010, my lord, the ROP came into force. ROP was adopted by the AIDC in 2012. So, and pre-revised scale of pay was granted in terms of ROP with effect from 2008. Then slash for government employees, my lord, they came with again a modified scheme which is called ACPS, Assured Career Progressive Scheme. This Assured Career Progressive Scheme will be applicable to the government employees. But so far, other state level enterprises like AIC, they have to adopt it. ACPS was never adopted by AIC. Now, if I take your lordship to the first to the slash, because I became entitled for the benefit under slash on 1st of January 2013, because I got the last promotion on 2012. On 1st of January 2013, I became entitled for the next higher scale of pay. I'm making it myself clear. So far, company secretary is concerned, there is no post like say GM company secretary. So only thing that I can claim is the upgradation and scale. I cannot claim promotion. So there is a difference between promotion and upgradation of skill, because a DGM has an option to if he has the DGM has the technical qualifications, then he is entitled to get the promotion to GM. But a company secretary will never be entitled to become a GM unless the government, this representation are all pending before the government. But unless the government formulates a scheme to promote the company secretary as GM company secretary, then it's different. But as on date, since I will not be having the technical qualification of GM, I will never become a GM of a public sector enterprises. Now, so far ROP 2010 is concerned, they have different pay band, and under the different pay band, they have different pay skills and grade pay. If I take your lordship first to the scheme of, I will come to the pay band. Your lordship will first look into the scheme under which I was entitled, that is / service advancement scheme, that your lordship will find at page 30 of the writ petition. This time I will refer to the running pages. We have updated the running pages. Now I will refer to the running pages, unlike referring to the 4 of the affidavit in
You are
opposition.
concerned with 31, no?
30.
Page 31.
No, but before that, your lordship will look at page 30. 31 will come, but now your lordship will look at page 30. This is of 21/9/2001, and your lordship will find the objective is to remove stagnation and motivate for effective working amongst the employees. Then scope. This scheme will cover all the employees of the corporation except the public enterprises selection post general manager and above. That means anyone who is holding the post of general manager, this scheme will not be applicable.
Will come under the ROP.
Yes, but means for general manager, you need to have technical qualifications and also. So I am holding the post below the GM, below the GM. They say the DGM equivalent post. So in case of me, it will be applicable. But since it is, I don't have the technical qualification, I will get only the upgradation in pay scale. So far the GM pay scale is concerned. Now your lordship will see, then your lordship will see the 4A. An employee who completes 10 years continuous satisfactory service, which I have completed, in the same grade or post from 2002 to 2013, I was given only a grade
Just
of
1 minute. Yes, Mr. Das, why are you waiting?
I remember showing.
Huh?
7.
7, no, it won't happen.
But date may be given.
What is that matter about?
It's a matter about EMD has been forfeited. EMD has been forfeited.
Next.
Matter which year?
22
EMD has been forfeited.
forfeited. 34 lakhs has been forfeited. Bona fide mistake on my part. That it is not a very long matter.
Initially also,
Any-
I request some more time, but minimum 10 days back to file an additional affidavit.
You want to file in that?
No,
The council appearing on behalf of
Yes, that's from him.
respondent number 1 and
1 and 2.
respondent number 1 and 2 seek for an accommodation for filing an additional affidavit. List the matter on 22nd of August 2020.
Deeply.
The additional affidavit be filed by 17th of August. Yes,
Now you'll have it. An employee who completes 10 years continuous satisfactory service in the same grade stroke post and is otherwise suitable for promotion to the next higher post as required under promotion rules, but remains stagnant due to non-availability of vacancy either for filling up the post by other incumbent or no other sanctioned post. I will fall under the category no other sanctioned post. I'll not fall into the first category because first category is for the, suppose there are 4 DGMs, post of GM are 2, so they will fall in that category. I will fall under no further sanctioned post. Will be eligible for being placed in the next higher scale in the approved pay structure as his personal scale of pay. The higher scale that may be granted as per personal scale of pay shall be restricted to the highest existing scale of pay of rupees 11,025 to 17,000, which I will now
get under slash. This is 11,000. This is the scale of the GM. So I will be entitled for 11,000, 25 to 70,000. In other words, employee up to the level of deputy general manager in the scale of pay of 10,000 and 15,500 will be entitled to this benefit. In case of upgradation of
say that your rank is of the deputy general.
deputy general,
How
So-
do you say that?
my pay scale is equivalent to the scale of deputy general. And one more aspect, my lord, in case of upgradation of scale from the level of deputy general manager to the level of to the scale of rupees 11,000 for 25 to 17,000, and if any vacancy arises at the general manager level, regularization of such employee to that level will be considered only as per the existing policy of the corporation directive from government. This is again applicable to the DGM people. I am not seeking promotion. I am seeking only this scale. Because I don't have that sanctioned post of GM for company secretary. I can only be entitled to this scale of 11,000, 25 to 70,000. Now your lordship will see the clauses which are being referred by the AADC is in the next page at page 32. Of course, this is the procedure, and that is clause E and F. The eligible employee under the scheme will be examined by the respective DPC PAC in respect of executive category and DPC staff in respect of staff category, and recommend upgradation of pay scale as per the promotion rules of the corporation, along with other cases of regular promotion if any subject to satisfaction. This is just a procedure matter. This scheme is in addition to the regular scheme of promotion which will take place as and when vacancies occurs in accordance with the so and so. So this two E and F relates to the procedural process only. Now your lordship will see that an interpretation is sought to be given in respect of I, and which is not applicable so far we are concerned. This scheme will not be applicable to those employees who are not eligible for promotion to the next highest post due to lack of requisite qualification. This is again the DGM. DGM, if she doesn't have the technical qualification to go to the next post of GM, or it may be in case of other posts also. Say for a typist, if he wants to be promoted as a stenographer grade 1 and he doesn't have the stenographer qualification, he will not get the scale of stenographer. This scheme will not be applicable to those employees who are not eligible for promotion to the next higher post due to lack of requisite qualification. Or there may be some qualification, like say, you need to have BTech from an engineering institute, but you have an ITI qualification from Assam Engineering Institute, Sanpare.
Okay. Now, why you can't be promoted to GM?
There is no post of GM company secretary. And the other GM posts all requires, which are in existence, requires technical qualification.
Now you don't have technical?
No, I can. That's why I'm not seeking promotion. I'm seeking.
Understood, but why I will not come?
No, I is in case of promotion. The scheme will not applicable to those employees
you don't
who are
have
not eligible for promotion to the next higher post due to lack of requisite qualification.
you don't have
This is in case. This is in respect of person who have a promotional post like the GM. Not for me. If your lordship again looks at A, where no further sanctioned post, that was I was saying that no further sanctioned post. I fall into the category of no further sanctioned post. Not in case of I. That's why I'm telling that this will be applicable. Suppose there are 2 GM posts, 4.
But anyway, they gave you 200 rupees.
200 rupees for.
No, understood.
Yes.
So that means I won't come in.
Huh?
So therefore,
Yes.
I won't come in
Yes,
because of the fact that they have giving you 200 rupees. They have duly admitted that this I is not applicable. Therefore, they have given you the benefit of slash.
Yes, lordship is absolute. Yes.
So therefore, the question is whether you are entitled to the GM
Pay scale on.
pay scale.
That is my whole case. Now your lordship will see. Now is so far the ROP 2000.
Isn't it?
Yes. But,
Huh? There you are already caught by giving him 200 rupees.
No, 200 rupees is as per the ROP rule 2010, Lord.
Understood.
Yes,
But
Lordship.
thereby,
That is the pay ban, last pay ban, Lordship.
Understood,
It's not the great pay of next higher post, Lordship.
whatever may be, thereby you accept that she is entitled to
The
slash.
last pay ban,
No, she may not be entitled to the GM scale.
Yes,
That's a different
yes,
thing, but she is entitled to slash. You have admitted.
no, not slash.
Then
Lordship.
Why have you given the higher?
ROP 10, Lordship. It is after adopting the ROP rules, Lordship. This the 200 rupees, the grade pay was increased after adopting the ROP rule.
No, my lord, this is factually incorrect. Let me place my facts, then
I will
it's
place.
better
I will
read
place
response.
it. I will place.
Now your lordship will see, I became eligible on 1/1/2013. Till that time, the scale of, I was, say I was working in 7,400. Your lordship will kindly recall that one piece of chart which they have given. I had marked it. I probably your lordship has it in the copy, my lord. This one, your lordship will not look it because I have marked that. But this is the copy.
Yes.
Move over today.
You have a copy?
I probably have one. Itu ya so it's no, no, I have my one. Now your lordship will see in that case 7,400, then 7,600 grade pay, then the GM scale. Now in the ROP, all grade scale pay is against a particular post. Here, there is no post. They have simply adopted the grade pay of 7,600. I will show the your lordship the ROP. Yes, sir. मेरा वाला कॉपी नहीं देना कहा था अरे ये वाला कॉपी. Now your lordship will kindly see this. I have given the extract of this whole ROP is big, so I have given this extract, my lord. Your lordship will see appendix 4, which is relevant. Appendix 4, my lord, the first serial number 1, say, my lord. Your lordship got this page, appendix 4. Now your lordship will see the pay band. Pay band 1, pay band 2, pay band 1. Pay band 1 is the first three. Your lordship has seen. Then the revised pay scale, your lordship will see 1,500, 1,500, 1,500. So this pay band of this or this scale does not define the post or position. The post or position is defined by 1,300, 1,400, 1,600. This will define the grade pay, will define the post. And if your lordship looks into the next page of that appendix 4, your lordship will find this 7,400 and that 7,600, then 8,700. Now all these pay bands are in respect of just answer it perfectly. Just a moment, my lord. I have.
You have a copy? Take it, take it.
और ये स्केल वाला भी कागज को चेक करने के लिए अब मेरा वाला अभी कहाँ है उसके में दूसरे पर okay. Now, if your lordship looks into that extract of the ROP, your lordship will find that all that 7,600 grade pay where it is given, it is always against a particular post. So far AIDC is concerned, my lord, your lordship will find this 7,600 was adopted. The scale was adopted from ROP 2010, but not against a particular post. And if you want to do this, if you want to, they have adopted this pay band along with the grade pay without even taking the approval of the government. I'll show it from their own document. Your lordship will kindly see at page 36 of the writ petition.
Yes.
Now, if your lordship, because I somehow photostat, I think he's left it in the machine. Photostat, but even then, my lord, That's why the rhythm is broken, but it's still, I'll try to be, page 36, your lordship will see, clause 3. As AIDC has not, and again, your lordship will take note of the date. This is the impugn order,
You're reading what?
page 36.
Page 36 is, this is page,
You have the repeat.
page.
This is the first impugn order.
Okay.
This is of 39/2013, and I became eligible on 1/1/2013. Now your lordship will see they themselves has admitted that as AIDC has not adopted the pre-revised scale of pay of rupees 10,000, 3,075-16,050, which has been revised to pay band of rupees 12,000, 40,000 plus grade pay of rupees 7,000. Hence, the board adopted that pay scale pay band to grant the benefit under the service length advancement scheme to the employees who are in the revised pay band of so and so, so and so, so and so. And this order is always prospective in effect, my lord.
Then
And this scale, my lord, this 7,600 was not in existence in AIDC since its inception, my lord.
yes.
And
there
our
was
case
some
is-
document you
Yeah.
showed somewhere. Now, what are you asking for?
Now, I am asking that, my lord, in that paper, my lord, which that this, a single page, wait, yes. This. I am asking that this scale, from your lordship will see the chart, this 7,600 is not applicable to me. I need to have this upgradation of the scale in terms of that 4A. That one means that is the scale of pay which I had referred at under slash 11,025 to 17,000.
Was there a grade pay earlier? No.
That
Of
pay-
AIDC? No. They were having a pay
but
scale. only.
it was earlier, before 2010, it is scale of pay. And Malad, so far ROP is concerned, ROP has been, once ROP is adopted, it has to be followed by all. But if you want to have a pay band with a new grade pay, you need to have the approval of the government. And you didn't have that approval of the government. And you didn't take to the government. Government asked theirs, even this scale which they have been adopted, this scheme which what AIDC has done, they have not taken this, adopted the ACPS, the subsequent after slash. Now we have another modified some progression scheme and all. What AIDC has done has taken some from ACPS, some from slash. And they came up with they called it modified slash, which is non-existent in any government department, which I have clarified from the finance department. Just because I have to deprive me and give only 200 rupees benefit, they have adopted it after I became eligible on 1/1/2013.
So the entire exercise for you only.
Yes, madam. Because that's why, and you'll also see, because this technical people, they don't want me to have the scale of the GM. That is the hostility, and the saddest part is that this lady is part of all the board meetings where all these decisions are taken. When her decision has been taken, she has to obey. Her services, because it was, my lord, she was the third company secretary from Assam. First was Rulidas, first was Kankana Mohantama from Tezpur. Rulidas from Ambari was second, and Sobita Tamoli was the third company secretary from Assam. At that time, my lord, the government organization, nobody used to join the government organization as a company secretary. She was my classmate. She was an exception. She decided to join AIDC. Now, today, when I share with my friend that look at her, that she gets only 200 rupees increment from 94 to 95, then the query that your lordship has asked me.
And a prominent trained lawyer who has not been able to get her the benefit for the last 7 years.
No. From 2015, this writ petition was filed in 2015.
That is what
My lord, there was a change in council in 2019, just before COVID. I got the first hearing in the March 2019, then COVID struck. Well, my last 2 years has gone in COVID. Now, after COVID also, she came to me so that she needed an early disposal.
So stakes are very high for Mr. Kaur.
Personal level. So this is Now your lordship will see.
Is she working
Yes.
now? Now, what is the
28
scale
years
she
of
is
service,
getting?
madam.
What is the scale she is getting?
At this moment, Lordship.
You see, AITC could not have taken the ROP unless it has been approved by the government. Because the ROP, as per the 2010 rule, has to be approved and there has to be notified by the government under Rule 2.
256 100.
Because it's a public sector, public
Yes.
enterprise. When was it then done? And was it made applicable from
ROP.
ROP?
Yes, Lord.
Miss ROP,
I will
your
come on that. Yes, I will.
ROP, when
Yes.
was it done?
Lord.
29 September 2012.
Yes. Lordship,
256 board.
may submit.
Yes.
I would like to,
26 9.
first, Lordship, I would like to address the court queries last occasion, Lordship. What is what
Mr.
is the-
Gustavi, I have forgot the query. That was the query was raised in the month of March.
Yes, Lordship, this is.
We
the-
are-
Yes.
We have already spent the quarter.
Yes.
In the meantime, so many times the adjournments have happened.
Query number one is that whether the AIDC was bound in terms of the memorandum of understanding entered into the government of Assam even prior to its adoption on 13/9/2013 to be bound by the Assam Service Revision of Payrolls 2010, Lordship. Is it, Lordship? Yes. After entered into the memorandum, Lordship, the memorandum of undertaking with the government of Assam, AIDC was bound in terms of the memorandum of undertaking, even its adoption on 13/9/2013, AIDC to be bound to the Assam Service Revision of Payrolls 2010, Lordship.
So
Number one.
you are bound after the memorandum of understanding.
Yes,
entered in.
yes, Lordship.
When was the memorandum
Yes.
of understanding? entered?
Memorandum of understanding was signed, Lordship, on. It was signed on, Lordship. Yes, it was signed on, Lordship, 12/9/2012. 12/9/2012.
Okay. 12/9/2012 you have.
Yes,
So on that day,
Yes.
have you applied the ROP to everybody?
yes, Lord. Yes, the second one,
On-
second query. I would like to address the second query.
Factually correct.
Yes.
Madam, your lordship will find all these details at page 204. The board meeting they have reflected the dates. Correct.
There was no any financial upgradation given to the rank of deputy general manager level officers in terms of authority of this match.
It is the court queries.
During
Lord.
the period from the date of entering into the memorandum of understand by the AITC with the government.
Yes, the court query is that whether during the period from the date of entering into the memorandum of understanding by the AIDC with the government of Assam till 13/9/2013, there was any financial upgradation given to those officers holding the rank of the deputy general manager in terms with clause A of the slash. This is the court query. This is
So you
our
say
answer.
no.
Yes, no, yes,
There was nobody.
yes, yes.
Now,
Except-
what has happened as regards the DGM who were there thereafter?
Other
There
disease.
were 4 DGMs.
Yeah,
There
yes,
were 4 DGMs.
yes.
What has happened? There were only 2 GM posts.
Yes, only two zeros. Yes.
Now,
Also
slash
600.
can be applied for 2 reasons.
Yes.
The first reason is
Or
if there is a stagnancy
Yes,
or there is no promotional avenues available.
yes.
Okay. Now, promotional avenues are available for the DGM to the GM.
Yes, I will come on that point.
No, you come to that only.
Yes, sir.
Now, promotional avenues are available from the DGM to GM.
Now, Lordship, in slash Lordship, in slash Lordship. So for first of all, Lordship, I would like to submit the in slash.
No, Mr. Goswami.
Yes.
Kindly come to my query.
Yeah. On that query, I will like
Why
to
need I? You have been dealing with these matters such a long time.
yes.
I'm asking you a specific question.
Yes.
There are 4 DGM posts, 2 GM posts.
Yes.
After 13/9/2023.
After 13/9.
2023.
Yes. ROP applied. Yeah.
You must have given somebody ACP or a slash or M slash, whatever it is.
Yes.
How have you treated them?
Within the pay band, Lordship, it was within the pay band, Lordship, it was upgraded. There are
Thereby increasing only the grade pay.
yes, Lordship, grade pay is there.
Where is
And Lordship,
Where is it?
yes. These are Lordship, it is in my affidavit, Lordship, kindly see the 17, 18, and 19, Lordship. Page number 37, Lordship. Page 37.
No, don't say about your affidavit different pages. No.
Running page. Paragraph number 1.
Yeah. Tell me which one? Serial number?
37, serial number 17, 18, and 19, Lordship.
Okay. Tell me the ACP.
Page 237 will be by
in the immediate higher grade pay within the existing pay band of the employee in the hierarchy of the existing band. However, employees in the receipt of the maximum grade pay in the pay band eligible under the would be given the benefit of one increment under the scheme without any change of pay band or grade. Does the grade pay after the
My lord, the clause which my learned friend is referred, it is from ACPS. ACPS was never adopted in AI discipline.
No, ACPS.
No, I'll show it from your own, my lord, because
No,
it has to be
ACPS was
adopted by the ACPS, the 240, page number 240, you also will see the relevant clause. The ACP does not be applicable automatically to public sector enterprises. It has to be adopted by
for employees of the government of Assam.
government of Assam, because your lordship has to read in consonance with page number.
Now, how can it be adopted?
But in the board meeting, it has to be adopted.
Lordship,
I'll refer to the board meeting.
kindly see the MOU, Lordship.
Where is the
ACPS was never adopted.
Oh, MOU, yeah,
Yes,
got
MOU
You
there,
cannot
Lordship.
create any new post without the approval.
That's not
Where is the ACP? Please take the prepare government.
It's a-
bill.
okay, right. Slash it. Would that-
Where is it? ACP has been approved.
ACP has to be adopted, that is in 34, but that is 240, page number 240.
Ah.
At top, the ACP is directly be applicable only to state government employees. They have adopted,
That too I've seen.
yeah, that they have already modified.
Chalo, we'll hear it again when.
Then you'll also look at the page number
Understood,
250.
we'll hear on some other day. Have to deliver one judgment, Mr. Purakohai. Today itself. On used hair. One thing good about bench 4 is that you get a variety of matters. Hello, when? You are under, also have a personal interest. So when?
Not personal, my lord. That marriage of this lady with the boy was also fixed by me. They both are my classmates.
But see, it's a lucky letter.
Lucky.
Yes.
Oh, my lord, as if,
Yes,
as if,
very
my lord,
lucky.
they are showing very,
Lots of advertisement in the for the post of company secretary. She is not qualified for the company secretary. She
What you are telling, she-
accepted assistant company secretary. It is in
God, but I'll not
her
reply.
representation, lordship. Her
Uh,
representation.
but these are all
Ah,
misplaced
okay,
sympathy.
yeah.
And
She is a
within
qualified company secretary in
within
2000.
5 years, lordship,
My lord,
he
at
got
that
2
time-
promotion, lordship.
Second grade, okay?
Well, I'll not dispute these things with my friend.
The very lucky.
Yes,
lucky.
when? When should we hear it again?
My lord, you are also.
2 weeks.
Have it on a Thursday. Let me go through the file a bit. I've got. You have given some judgments here.
No.
And what is the state of Assam saying? Who is appealing for state of Assam?
The state of Assam, my lord, queries have been sent by the state of Assam in regard to how you have created this pay scale without the approval of the government. They don't reply to that.
No, but who is appearing for the pay?
But the industry department earlier, Anjan used to appear.
Anjan Kalita.
He's
But
not
now-
appearing today.
Now I think,
I think
change
left.
of councils over.
His junior was there, lordship, but presently.
When?
3rd of August, my lord.
Huh?
3rd of August.
Okay.
Thursday.
Okay. Third of- It's the matter for further hearing on 3rd of August. Must. Take it,